I beg to mention for item number 7, madam. I pay for adjournment for today, madam.
719 matter.
19 madam, but any other day, madam. I have some difficulty, madam. I could not prepare the case.
Okay, Monday.
My,
On a request made by SP AR Sigdar, learned counsel for the petitioner. Matter is adjourned to be listed on Monday next.
The content of the other one, I think you mentioned item number 17.
17.
They need to file an additional affidavit. 2 weeks time will be granted.
EO for the Education Department.
Education.
On a request by SP NJ Khatoniya, Learned Standing Council, Secondary Education. Matter is adjourned by 2 weeks to enable filing of additional affidavit.
May I please, Lordship? So I beg to mention item number 3, Lordship.
Pencil diya na hai. 3?
Yes, Lordship. MSP Bhattacharya, additional AG for State of Mizoram is supposed to appear in this matter, Lordship, but she is in bereavement, Lordship. I have informed the other side.
Who will appear?
P. Bhattacharya.
B. Bhattacharya.
Yes. She-
B. Bhattacharya.
Yes. MS.
Oh.
Item.
What has happened? Who has passed away?
Her younger sister has
Is it
passed
so?
away last night.
Last night.
Lordship?
Last night.
Last night, yes.
She appears from whom?
Top Mizoram, Lordship.
Mizoram. Okay.
Yes.
Have you informed the other side?
Yes, I have informed.
On a request made on behalf of. No, a request has been made on behalf of Ms. P. Bhattacharya, learned additional AG, Mizoram, on personal grounds. Para. Matter is accordingly adjourned to be
2
listed
weeks, Lordship.
after 2 weeks. We give a date. List on. We'll have it on 10th of August.
Lordship.
10/8.
Obligation.
On the 9, Lordship.
9, yes.
Lordship.
Milord, Lordship can fix this, huh?
9.
Oh, sorry.
9, yes. What is it? In PIL of 21, you have not filed affidavit till now.
The instructions were awaited, Lordship.
A request has been made on behalf of the central government to allow time to file affidavit in opposition. Para. Considering that this PIL is pending since the year 2021, a last opportunity of 2 weeks is granted to file such affidavit. Full stop. List on 10th of August. 10/8.
Lordship, in item number 22, Lordship.
22. You are there.
I'm there, madam. I'm for the petitioner, Milord.
22 supply list. Oh, daily.
Main list. Item 22. Milord, where we have challenged the requirement advised by the tea board that 100% of the orthodox tea should be sold through auction.
Okay. Now what is your prayer?
Lordship, Mr. RKD Chaudhary is out of station, so matter may be fixed.
When do we have?
Milord, let it be in the last week of August, Milord, because from tomorrow onwards, CAA matters are being heard.
Okay.
Supreme Court.
Our request for adjournment has been made on behalf of Sri RKD Chaudhary, Learned Senior Counsel, representing the central government. Para. Sri K.N. Chaudhary, Learned Senior Counsel for the petitioner is present. Para. Matter accordingly stands adjourned to be listed on 24th of August.
Deeply.
May please, Your Honor. To mention this for listing of the matter. It
What
is for
stage?
Admission.
Admission. What
On the
matter?
last stage, it was left over, Your Lordship.
Admission of which year?
2026.
26. Why? What is the urgency?
Season detention came, Your Lordship.
FT matter.
FT matter. And on the last day, it was left over, Your Lordship.
Admission records have come.
Yes, record is.
Hmm?
Here, not here. Lordship. I need to
No,
mention.
in the records have come or not in the main case? The
tribunal
records. Tribunal records have
Yes,
come.
yes.
It was called for.
Yes, because there is it's for the bail matter, Your Lordship, for the release matter, not for the challenging the citizenship. It's for the release of the detainee, Your Lordship.
Release of the detainee, why have you filed a petition?
In the
Okay, on Monday.
Lordship, I beg to mention item number 4.
4, yes.
Yes, I am seeking an adjournment today, Lordship. The engaged counsel is having some health issues today.
Who is the engaged counsel?
P. Upadhyay, sir.
19 matter. A request for adjournment has been made on behalf of Sri P. Upadhyay on personal grounds. Para. Matter is accordingly adjourned to be listed on Tuesday next. Tuesday.
Wait, please, your lordship. Lordship, in item 6, I may be allowed to peruse the TCR, lordship, trial court record.
Yes, you want to?
Peruse the trial court
You
record.
parents?
May I please, your lordship? Lordship, I beg to mention number 20, your lordship.
20.
20.
Yes.
Praying for an adjournment for the day. Due to some personal difficulty of the conducting counsel, your lordship.
On Monday, we'll have it on Monday.
1 week may be given you.
Where are we seeking time?
His personal difficulty here.
Personal difficulty today.
On
Monday we are fixing.
There is another
Huh?
Tuesday, my lordship.
Hearing negate, okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on Tuesday. Date, huh?
May I please, your lordship? Your lordship, I beg to mention to read petition for listing in motion column, lordship.
Okay.
Can
When?
you read Monday, lordship?
Your lordship, I beg to mention item number 5, lordship,
Yes,
with the consent of the other side,
yes.
may it be adjourned and may it be fixed next week.
Why are you seeking adjournment?
Lordship, I have some little difficulty today, so in next week, after Tuesday, any day, Lord. And as per.
These are all matters, madam. Why do you seek time?
Because I have some personal difficulties today to argue the matter.
Okay,
But
on a request,
After Tuesday, any day.
on a
Lordship.
request made by Miss Anonymous D. Ghosh, learned counsel for the petitioner submits that she has got some personal difficulties today and accordingly prays for fixing this matter in the next week. Para. List, accordingly list this matter. Accordingly, matter stands adjourned to be listed on Thursday next. Thursday.
Deeply open.
May it please, your lordship. Lord, in this case, we have
Just-
challenged me, Lord.
Just a minute, just
Yeah.
a minute. Yes.
Yes. My lord, basically what we are trying to project is, my lord, after coming into force of the Central Act of 2013, with effect from 1/1/2014, the Assam Act of 1964, my lord, stood repeal because of the repugnancy in the Assam Act, qua the Act of 2013.
Has it been expressly repealed?
No, impliedly. That is our projection, my lord. Secondly, my lord, since the Assam Act of 1964 stood repeal, any amendment, Assam state amendment of the Central Act, my lord, even if presidential assent is received, it will not cure the, my lord, repugnancy. Therefore, that will also stand repealed. Therefore, that is also ultra vires, my lord. Yes. Now, my lord, to formulate my arguments, if your lordship would kindly come to the constitution first, my lord.
Just ignore lordship.
A4.
In this case, notice was issued. I ordered a date because there's no point of hearing the matter today. 21/7/2026.
Notice has already been
Notice
issued.
has been issued, interim order has been granted in their favor. And we have to file affidavit. And this matter, paragraph 5 of that order, lordship will kindly
Mr.
see.
AG, perhaps notice has not been issued.
No, notice was not issued.
It was,
Lordship kindly paragraph 5 of
no,
the order. It made
oh, yes,
a-
yeah, you're correct. Court is inclined to issue notice.
Yes.
The-
No, no, Lord.
And therefore, the matter has been fixed on 27. The other 10 cases are listed at 2 PM before court number 1. So we are going to file an affidavit. That's why no point of hearing the
No, my
matter.
lord.
We'll file an affidavit
No,
in this case.
let me make my position clear.
The
I
other
have
matters are similar.
No, my lord, same matter.
Same matter.
Same
No,
matter, item
No,
number
now,
3.
now your lordships will have a look in the order sheet, order dated 17/6.
17.
17/7. 7. 17/7 in this batch of cases.
Hmm.
These matters were referred to, my lord, bench 2. That's why I started with my argument. Yes, today, my lord, by mistake, the other 3 matters have been listed before court number 1. My junior is there, my lord. He will make a mention so that the matters are transferred. Because the Honorable Chief Justice was of the view that since bench 2 has heard the matter, it should be heard by the bench 2.
Then in-
Difficulty on the bench, but
No,
the
no, no,
affidavit.
in that case, let the affidavit be filed.
No, affidavit
since-
has been filed. In the main case, affidavit has been filed.
In
3517.
this case, we have not filed it.
No, same case, my lord, same question of law.
That is
Only
our right in which
only
case it is
Azara
filed.
village is different.
No, Mr. Chaudhary, if the AG concedes that
Huh.
one affidavit will cover,
Huh.
then, but if we cannot preclude him from
No,
filing
no,
affidavit.
Because the idea was on 20, today the date matter will be heard.
Okay.
That's why my lord, it was on their prayer, it was early date was given. Because kindly see why so short date was given. Because they expressed their urgency.
No, we did not express our
Then,
urgency. We
let-
only said that all the cases should be heard together.
Let it come before the regular DB2 on Tuesday. In the meantime, if you want, you can file the affidavit. We'll extend the interim orders and you can make a request before the DB1 and disclosing about the 17/7 order.
Hmm.
And it can be
No,
taken
in fact,
together.
my lord, consciously, my lord, my learned friend Borpujari was present. He will explain, my lord. These matters were referred to, my lord.
No,
DB2.
it's okay.
We are not disputing on any proposition. We are not
No,
disputing.
there's no difficulty for us to take up the matter, but it should be taken up
Even
together.
I am free to argue the matter before you. We are not bench hunting. That is not our prerogative or.
No, but this is a very temporary kind of a thing for today and tomorrow. So, because the bench has to be reconstituted, we can have it on Tuesday.
No, no, my lord, instead of Tuesday, let these matters come on Thursday.
Thursday, Mr. AG, Thursday,
I have no difficulty.
you can file the AG, affidavit.
Yes, Lord, if you wish.
Thursday. Okay.
Our affidavit is
Oh.
already almost been prepared.
Okay.
Deputy
Heard,
Commissioner
heard
will
Sri
be-
K. N. Chaudhary, Learned Senior Counsel, assisted by A.U. Ahmed.
Yes.
Also heard Sri D. Saikia, Learned Advocate General, assisted by Sri R. Borpujari for the for the state respondents. Para. It has been informed that similar matters, 10 in numbers,
No, my lord, as far as I am appearing in 3 other matters.
There are much more than that.
and the
Today-
similar matters are
Today, item number 3 to item number 10.
Similar matters
Eight
have
matters
been
are
listed today before DB1. Full stop.
At 2 PM.
At 2 PM. Full stop. Sri Chaudhary, the Learned Senior Counsel, has also drawn the attention of this court to the order dated 17/7/2026, where the DB1 had expressed an opinion that the matter should be placed before the DB2. Full stop. Since the learned AG at this stage submits that though affidavit has been filed in the other cases, an affidavit would also be like to be filed in this case. Full stop. Let such affidavit be filed and the matters be listed together on Thursday before the appropriate bench.
Highly of-
Take care.
Interim order?
To
Is it-
continue, my lord.
Interim order passed earlier to continue till the next date of listing.
deeply of.
Deep level.
Okay, right. Kindly publish it. For the item number 20.
20.
Uh, Friend has mentioned the matter.
Yes,
Lordship has speak from Tuesday. Can you do?
Thursday it can be done. Should take the consent Thursday, Tuesday. Item 20.
Tuesday, 20.
Represents to record dinner for the appear as state council, senior council.
Got it.
Item 1.
May please, Lordship. So perhaps this is a review petition, Lordship. Perhaps this matter has been inadvertently listed before this bench, Lordship.
Review of which order?
Lordship, may kindly see page 18. The order is which is sought to be reviewed. It's passed by Honorable Justice Monojit Bhuya and Honorable Justice Monish Chaudhary, Lordship. So the matter may kindly be listed before the appropriate bench.
So what is the norm?
There is a ballot,
One of the judges is available if
Yeah.
available.
If available.
last time, my lord, I mentioned that.
Hmm.
But probably there is a noting from the civil justice.
There is a note. But on the last occasion 14/7,
Yes.
court has expressed reluctancy in granting adjournment as
Right.
this is a review petition of 2021.
Probably that-
Unless there is a norm
Yes.
that it should be placed before one of the judges.
It is there, Lordship.
That norms probably.
Why didn't you point it out on the last occasion?
I was not there. The adjournment was sought, Lordship.
But both sides were represented.
Yes, I was not there, Lordship. It is, Lordship, may kindly see there is a note, Lordship. When one of the judges is available.
Which order? Which?
Yes, on-
Which office not?
There's a list, Lordship.
4/8/2022. All have to be listed before the DB2,
Yes.
except this review petitions, a few numbered.
Yes, other item was.
This
items
is
are
not
also
one
there.
of them, right? 22, except
When
No,
both
it's
the honorable judges are not available, it will be listed before the regular bench, Lordship. When one of the judges is available, then Lordship.
and available judge.
No.
He question, good question.
That means one of the judges taking the DB2,
Yes,
and the other judge should be the
should
who
be.
had passed the order.
Yes. Yeah. Since Justice Chaudhary is there, Lordship.
So it has to be specially constituted then.
Especially.
Now, which part of this office not?
Seems so.
Registry may be allowed to list the above referred review petitions before the honorable judge taking up foreigners tribunals matters and the available honorable judge accept review petition so and so so and
It
so,
should be before division DB1.
which should be honorable division bench.
Specifically named.
In
review
those matters, the both the honorable judges have been retired, Lordship. That's
petition.
why.
That's okay, that's okay.
But
And
where is
otherwise,
14? Where is 14? Where is
14
the
is
mention of 14?
There.
one of the available judges.
Yes.
Has to be part of.
It was earlier listed also before that bench.
What do you say, Mr.
My lord, I pointed out this also, last occasion also this point, that it should probably listed as appropriate. Would express that there is a noting from the honorable chief justice.
There is?
There is noting from the honorable chief justice.
Yes.
That's why this matter was continued.
Has the time also.
Let us see where is the note. Hmm.
That is the normal force Lordship.
Okay. What is your name?
And Hassan.
Howard Sri N. Hassan, learned counsel for the petitioner as well as Sri J. Payang, learned standing counsel Home Department, comma Sri Gutega number A.I. Ali, standing counsel Election Commission of India, comma Ms. Sri P. Sharma, Learned State Council. Para. The Learned Council has drawn the attention of this court to the circular dated 28/7/2022 and has submitted that the matter has to be listed before an appropriate bench. Appropriate bench. Para. Raise free to examine and list before the appropriate bench.
Obliged.
Lord, kindly see the last order at 15.
You are appearing on person.
Yes, my lord. Yeah, my lord.
I is for implement of.
You want yourself to be implemented.
The lordship.
What is
my
your
lord.
writ
Lordship, kindly
petition?
see last order at 15/6/2026. The regular division bench has raised the issue of maintainability. In fact, it was hard in length, my lord. And thereafter, direction was given them to file affidavit in opposition, my lord. My lord, affidavit.
Maintainability of the IA.
My lord.
Because this is a organization of women nearby the vicinity of the Barpeta Hotra Milot. And they opposes this, they want to oppose this PIL Milot. Therefore, Milot, they wanted to implead here in this petition. Today morning, I am told, Milot, the issue raised by my friend is this.
Now, what is the fate of the IA? It is still.
IA is this, my lord, it is still pending, my lord. The objection is from the petitioner side is that the organization is not registered, therefore we do not have a right to be implemented. My lord, there are judgments, my lord. One judgment I still hold, I can place before lordship. But today morning, I am told, my lord, this organization has been registered. But the registration certificate is not yet been.
You file an affidavit and put it on record?
My lord, okay. This will do.
Okay. Heard 3H Hamo Learned Council for the applicant as well as 3 as summary learned the summary petition in person. Full stop. 3 Chamo, the Learned Council has submitted that there are materials which are required to be put on record by way of an additional affidavit.
Right.
Para? Let such additional affidavit be filed within a period of 2 weeks. 2 weeks from today.
Well,
And the matter be listed thereafter. What is your name? Three Miss U Roy, Learned Council for the Respondable. 3456 are is present. You are also for somebody. P. Sharma, State Council. Private respondent. What is your name? M. Sharma for R7.
well,
Obliged.
Yes.
Impugn order in page 68.
এইটো অকণ হেৰিটো বঢ়াই দিবা না চাউণ্ডটো চাউণ্ডটো অলপ কম আছে অলপ amplification-টো Yes, which one?
Page 68.
ঠিক আছে বঢ়িয়া 68
68, 29/5/18. One Nachi.
That's why these two gentlemen standing. Is there any personal appearance? And why are you standing in the court? Are you appearing in person? Then what is there to see? Either you sit or you wait outside and don't stand like this. Sit down. Your counsel is there. What is there to see? Unless we direct your personal appearance, we're not supposed to be here. Number 10,
Connected with read appeals.
Or
Yeah, people better CB.
ID?
CB.
CD, okay.
Where is it?
What is your name? Ilsen.
Yes, Your Lordship.
CGC, who's there? CGC? CGC? Central government, who's present? Okay, yes, by the impute order 68,
Your Lordship.
name Pawan Maji.
Pawan.
Date of the 29/5. 29/5/18.
Your Lordship.
Which FT? FC Nalbari number 1. Yes.
Lordship, petitioner could not establish link with his father through voter list. Lordship, petitioner read in a school, in a lower primary school in a Fihu, and that school issued a certificate that was Exhibit 10, and here is a annexure 13, Lordship, page 64. And school headmaster appeared before the learned tribunal and produced the register, admission registered, and he deposed that his earlier predecessor has issued that certificate. And as per certificate, he was admitted at the age of 5 in the year 1970. In the year 1970, Lordship. And if he is
What is your date of birth? Year of birth or date of birth?
Lordship, date of birth, he has written 34/1965.
30,
4,
1965.
1965, Lordship.
Okay. When did you file written statement?
Uh, 2/5/2017, Lordship.
2/5/17. How many witnesses did you produce?
Petitioners, PW1, and school headmaster, PW2, and Gavura, PW3, Lordship.
3 witnesses.
3 witnesses.
Petitioner, school headmaster,
School headmaster,
and Gauhati.
Gavura, Lordship.
Okay.
Lordship.
Let us go chronologically. What are the
Lordship.
documents?
Lordship. Page 48, Lordship.
Page
48, Lordship.
48. Yes, what is 48?
Lordship, electro photo identity card of the petitioner.
Huh?
Voter ID card, Lordship.
Voter record, you show us relevant documents, Mr. Hussain.
That on its own may not be sufficient.
Lordship, only reliable.
Epic will not do.
Alone may not be sufficient.
Lordship. Then page 6, Lordship, two documents is there. Lordship, that is established that he is present in the Tihu since 1970 and his father is Abdul Kader and Kader Mazi. Lordship. Lordship, then come to the evidence, Lordship, a cross-examination for Lordship.
Now documents, first documents.
Lordship, then page 64, Lordship.
6-4.
64.
What is 64?
29 Hottuson.
This was issued 8/9/1986, Lordship.
What is this?
This is the school certificate. The petitioner admitted in.
Please read.
Lordship,
School certificate in a blank paper.
that original
Blank
is
sheet of paper.
Lordship, that original was in record, Lordship.
No, blank paper. There is no letterhead.
Letter.
Huh?
Letter.
No letterhead.
That is not.
Please read. Nalbari Jilar Boroma, Tihu, Nagoror, Mohammad Abdul, Kadir Putra, Mohammad
Ali,
Pawan Alir,
Munsri Sheikh,
Tarike A. Vidyarat, Bhoti, নাম ভর্তি করা আছে। Eight nine 89.
in 86, it was issued.
Tihu JB School.
HP.
Hmm?
Q.
Q.
25, 86. 25, 86.
So 8999.
This is different. No.
Original.
No, this one. JB. Original counterpart. This was not exhibited during the.
Exhibited, Lordship.
This was exhibited.
Lordship, Exhibit 10, Lordship.
Exhibit
10,
A
Lordship.
without any letterhead.
That was issued not in a letter page, Lordship. It's only in page, Lordship. That was originally, Lordship, in record, Lordship. That
No,
certificate.
in record we find something, some other school.
No, Lordship. That seal was put at Tihu JB School, Lordship.
What is exhibit 5?
Exhibit 10, Lordship. This
What is exhibit 5?
Exhibit 5 is another school certificate after complete his primary. Lower primary, he has admitted in Tihu Boys High School, Lordship. Yes.
After 64, which document do you rely upon? After page 64? After page 64, which document do you rely upon?
64, that annexer 9 lordship, page 57, that Tihu Boys High School also issued a certificate, but that was, headmaster was not present, appeared before the tribunal to prove that.
59.
Lordship, 59, 57 lordship, annexer 9 lordship. And that was exhibited as exhibit 5 lordship.
This is not proved by the headmaster.
Lordship.
Headmaster put form.
Yeah, that is on letterhead, but not by the
Hmm.
headmaster.
Thereafter,
Lordship. Annexer 10,
page,
page 59 lordship.
what is this?
Lordship, the Deputy Commissioner Office of Nolbari issued a residential certificate that petitioner is a resident of Tihu Town Lordship.
Who gave?
Nolbari Zilla
Deputy
Upayukta,
Commissioner's Office. Page?
page 59 lordship, annexer 10. And it was exhibited as exhibit 6 lordship.
It's 6.
What has been written?
Written is that Pabon Ali, Pita Abdul Kader, Thana Antargata Tihu Mouza Tihu Gao, Nolbari Zillar Nolbari Mahakumar এজন স্থায়ী বাসিন্দা হয়। Another takes town committee, page 61 lordship. In the year 1966, 1967, tax was fixed.
কার্যালয়ের নথি, this is of 17 সূত্রে দেখা যায় যে মোহাম্মদ কাদির মাঝি পিতা সোয়েন্সো
মাঝি টিহু টাউনৰ 3 নং ৱাৰ্ডৰ 257 নং ঘৰৰ 1964 চনৰ পৰা ধাৰ্য কৰা দেখা যায়।
This is father of the petitioner.
Father of the petition.
So you need to establish your link with this Mohammad Kadir
Kadir.
Majhi.
Lordship, and page 55, Gowra certificate.
55.
Lordship.
Yes, Gauhati had come
Lordship,
as DW
Lordship,
3,
PW two, Lordship.
DW 2,
Once, no, three, Lordship, Lordship.
Three.
Sorry, three.
2 is the headmaster, I think.
Mm.
Please check.
Two is headmaster, Lordship.
Yes.
One voter list of 1955 that was submitted Xerox copy, or certificate copy was not. That was annexed as annexer 18, page 73, Lordship. Then where petitioner father's name appeared, Lordship, in at page 75, Lordship. Serial number 429. Kadir Mazi, son of Aksu Mazi.
Yes, the Xerox copy is shown too.
Lordship, Xerox copy.
Voter list of which year?
1955, Lordship.
1955.
Lordship.
Kadir Maji is your projected father.
His father is Kadir Mazi, Abdul Kadir. Mazi, some his written in Mazi, some is Abdul Kadir. So petitioner name appear in the voter list 1997.
1990?
7, Lordship. Page 50, Lordship, 50.
'51. 1997. Pawan Ali. You are Pawan Maji.
Pawan Ali and somewhere Pawan Mazi. Good name is Pawan Ali.
Pawan Ali, and what is the name here of the father?
Abdul Kadir. Kadir was not written, Lordship.
Only Abdul is written.
Only Abdul is written.
Your father's name is Kadir Maji.
Lordship, somewhere in both a petitioner and petitioner father.
There has to be some consistency. You had relied upon a voter list of 1955. Father's name is Kadir Maji.
Lordship.
You say your name is Pawan Maji. Now you are trying to rely upon a voter list where name is Pawan Ali and father's name is Abdul. Both sides there is inconsistency.
Abdul is very different from Kadir Maji. Names.
Later, 2016 voter list is already. 2016 voter list also exists. Page 52.
2016,
2016. Page 52.
52. Promotionally.
His good name is Pogon and his family Pogon.
Oh. Let us see the deposition of this headmaster who had
Page 66.
66.
Lordship. Annexure 15.
There is no countersign. And the name of the school has not been written.
His full name is Dear Lordship.
The seal is Tihu JB School. Correct? And the headmaster says that he is headmaster of Tihu Adarkho Nimno Bunyadi.
Vidyalaya. That was written in Assamese also, Lordship. Tihu Adarkho Nimno Bunyadi Vidyalaya. But seal was put, that is Tihu JB School. Lordship.
JB means
That was,
there has to be some connection. The seal may be in English language. What is JB?
Devi School, junior boys, something like that.
Now, he has to at least explain this witness who had come. First, he has not issued this. It was issued by another headmaster.
That was issued in the year 1986, Lordship, and deposition was on 2017, Lordship.
Understood. A new person has come. It may be
Lordship.
possible.
Lordship.
But he has to at least correctly state the name of the school.
So that admission register was produced, that was proof in original, Lordship. That is in record.
See, this deposition cannot be read in isolation. This deposition is intrinsically connected with the certificate. If certificate is not there, his deposition goes. It is only to prove the certificate,
Yes,
which would produce a link.
Lordship.
So we have to examine from that point of view. Certificate is in a blank piece of paper.
Lordship.
There is a seal, no doubt.
Lordship.
Seal says that the name of the school is Tihu JB School. In his entire deposition, he has not said a single whisper that he is the headmaster of Tihu JB School.
He says the Nimno Bunyadi School.
So he has to say that Nimna Budyadi and JB School is the same. Earlier it was JB School. We cannot assume. Because this deposition is meaningless if the certificate goes. It is only to prove the certificate he has come to the witness box.
Registered book corroborate the certificate. Lordship. That registered book that was proof in original, that corroborate the Lordship certificate that he was admitted.
And name of the student is Pawan Ali.
Pavan
And the certificate is given in the name of whom?
Ali.
Pawan Ali. You are Pawan Majhi.
Having some documents written Pavan Majhi, but
No, you have to make out you may have two names, no problem. You have to establish by convincing evidence.
Documents is there. The petitioner is a resident of Tihu since 1970, but that was not properly established or.
So if it is not proved, that will not suffice. That will not be sufficient. You have to prove.
It is established that petitioner is since 1970 in Tihu, Lordship.
Where from? Where established from where?
From the deposition of the teacher and school documents, Lordship.
Teacher is of different person. It's a Pawan Ali.
Petitioner is a
School name is not there. How do you depend on this?
School name is there, Lordship. Seal is different, Lordship.
No, school. So that is what we say. That is inconsistency. This is a different school. Headmaster is of a different school. He talks about one Pawan Ali.
Lordship, headmaster is Tihu Adorka Nimno Buni. That was he said, Lordship, in first line, headmaster.
Yes.
But regarding that seal, Lordship, neither any question was put, not he has made any.
So we have to examine.
Lordship.
We have to examine, isn't it?
Lordship, remand this back, Lordship, case. That petitioner.
Remand, we have to make out a case for remand. Remand is not for asking. You have to show gross error that materials are there. In spite of that, it was not considered. We will definitely remand. Let us see your written statement.
Page 41.
41. Let us read.
That the state of Assam /SP border null.
That is okay, not.
The para 3, that the Opposite party was born on 30/4/1965 at TU Town, Ward number 3 under PSTU and under present district Nolbari Assam. The father of the opposite party was known as Abdul Qadir alias Qadir Mazi, Qadir Ali at the time of during his lifetime. That the name of grandfather of the opposite party is Absu Mazi. 6. That the Zulil Mazi and Abdul Qadir Mazi, Qadir Ali is son of Absu Mazi. 7. That the OP's father name has been enlisted in the NRC details file so and so. Father of the opposite party's name has been enlisted in the voter list 1955 under 45 number LSC serial number 429 house number 8 of TU Town. The school certificate of the name of MD Pawan Ali, son of Abdul Qadir, that he was left school when he was reading in class 6 on 1977, which is issued by headmaster of TU Boys High School. That the school certificate of the name of Pawan Ali, son of Abdul Qadir, that he was reading at TU JV school, and as per school certificate, he was admitted in the school 1970, which is issued by headmaster of TU JV school. That in the name of opposite party, that is Pawan Ali, has a permanent residentship certificate at reside TU Town prior under Borma PS in the district of Nolbari, which is issued by Deputy Commissioner Nolbari dated 5/7/1986. That the OP has obtained the electoral photo identity card, so and so. That the opposite party executed one affidavit that his father name is known as Abdul Qadir alias Qadir Mazi, Qadir Ali in his lifetime.
You have not disclosed the name of your mother,
That was not written.
not disclosed. Father, grandfather, you have said. And your siblings? Your siblings? Any?
It was in his deposition mentioned.
Hmm?
In his deposition, he mentioned, but in written statement, in evidence, it was not mentioned. Petitioner has one son, Mustafa Ali, that was written in his deposition version, but not in written statement.
We have not understood. What is it?
Regarding his sibling lost,
Siblings, yes.
petitioner has mentioned in his
Deposition.
deposition letter.
Yes, that you have said, sir.
His one son is Mustafa Ali, and he has Zulil and Abdul Qadir is a paternal uncle, and his father Zulil and Abdul Qadir.
Jalil Ali you have mentioned in the written statement. Jalil Maji and Abdul Qadir are son of Absu. Absu is your grandfather.
project example.
Let us see your deposition.
Lordship, page 65.
60.
65.
Yes.
I am OP of this case. My fathers have two brothers, namely Kadir Mazi and late Jolil Mazi. Two sisters, namely Kamala Pera. My grandfather's name is late Apsu Mazi alias Azimuddin. I do not know the name of my grandmother. I got married with Zaritha Begum in 1997. I have one son, namely Mustafa Ali. My family is residing in the land of BOC of Tihu town. I do not have any own land. I have three brothers and one sister. Zulhas Ali, Zoinal Ali, Mustammad Syria Begum, and myself. I read in Tihu Adarsa Nimna Bunyadi Vidyalaya in 1970 up to class 6. It is not a fact that I was born in Bangladesh.
Cross examination. Cross.
Perhaps this is cross. He submitted evidence in civil lawsuit.
Let us see that. Let us see that.
Page 46. Lordship.
Yes.
I am fully aware about the facts deposed below. The allegation made against me by the complainant state is vague, false, fabricated. That I am denied all the allegations raised against me is made only to harass me mentally and economically. That I am an Indian national by birth, having my paternal residence as Tihu town, ward number 3, PSTU in the district of Nalbari, Assam. That being the Indian citizen, my ancestor had been enjoyed all the right and privilege enshrined in Indian constitution. That my father Abdul Kader, alias Kader Mazi's name has been enriched in the NRC details. I am also enjoying the political rights like my ancestor, and my name has been enlisted in the voter list of 42 number Patasargo CLSC fight serial number 15 and house number 3 and my voter ID card number so and so. That I was a student of Tihu Boys School from 1970 to 1977. That I am Indian national, hence the allegation is liable to be dismissed. And list of exhibit is here. Late bottom. And two school certificate. The boys school is Tihu Boys School exhibit 5 and Nimna Buniyadi school is exhibit 10.
He has not mentioned anything about the earlier school in his deposition. The Bunyadi school or JB school, whatever you say.
Boys school is later one, initially Buniyadi.
He has not mentioned.
Yes, in his deposition mentioned regarding Adarsa Nimna Buniyadi school.
Deposition.
In deposition.
Where has he mentioned? Huh? He has not mentioned. Deposition is mentioned about only
Yes,
the
sir.
high school.
I read in Tihu Adarsan. Deposition in since 1972, 1977. Lordship.
Where is it, where in the depositions? Paragraph?
So it's
Eight,
stated in the
Lordship.
deposition.
Para eight,
Stated there in the deposition.
8. That is Tihu Boys High School.
1970. Initially, he was admitted in 1970 that Adarsan Nimna Buniyadi, and later after
There will be more inconsistency.
Boys High School.
Boys High School.
the certificate is lost.
Boys High School has not been proved. He has said about Boys High School.
Lordship, that was drafted by the youngest council, that was not disclosed, Lordship, properly.
He has attended after he is a matriculate.
No, up to class 6, Lordship.
Nonetheless, he can sign, he can write, he can read. Which is your first voter list? 1997. 97. So, what about the voter list
Is 50.
of the earlier period of time in 97? This
22.
Pavonali, let us assume that you are Pavonali.
28 years.
You are 28 years.
Yes, I have
21.
stated that through the voter list, he could not establish this linkage with his father.
No, not about the linkage part. Linkage would be one aspect.
Voters list not there.
Lordship,
You are aged 28 years in 1997.
he was, Lordship, eligible in 1986 as a voter, Lordship, to win in 86, but his name was enrolled in the first time 1997, Lordship.
Why? At the age of 28. Why your name was not there in any other earlier voter list?
Perhaps he is not conscious, Lordship.
He went to school, you project that he had gone to school.
That is right, Lordship. Correct, Lordship.
Then he will not, if it's not done. See, the burden is upon you.
That is correct, Lordship.
The natural question, obvious question is, if you have attained the age of voting in the year sometime 1986,
Yes.
85, 65 you are born, isn't it?
Yes.
75, 85, 86, 1986,
21 years.
21
plus,
years.
Lordship.
It became 18 years only in 1989. It was reduced to 18 years in 1989. So it was 21 years of 1986. 86 to 1997, you don't have a single voter list.
That was not submitted. So my submission is that his presence in the Tihu town since 1970,
That
that
is
is
your
correct,
main-
Lordship. That was
that is your main
established, Lordship.
contention.
That is submission. And through
Presence
other-
in TU school in 1970.
Lordship.
That is your main contention. Question is whether that is proved properly. That has to be seen. Because of the infirmities.
Yes, anything else?
Lordship. This is-
Bye.
Yeah, a simple question, my lord. If the lordship may kindly say page 47, what documents you have exhibited, my lord? Page 47. This is the evidence of the PW1, my lord, PW. He exhibited 10 numbers of documents, my lord.
Hmm.
First, the voter ID of Pavonali, number 1. certified copy of the voter list of 1997 of Pavonali, certified copy of the voter list of 2016 of Pavonali, then a Gaumura certificate, then a school certificate. Probably this is school certificate means the school certificate issued by the high school, Tihu Boys High School. Then permanent residential certificate, NRC, municipality notice, certificate of Tihu Town Committee. Then lastly, school certificate of 1970. That means probably it is the Nimno Bunyadi school certificate. These are the documents which are exhibited. Now, my learned friend has earlier stated that the father had a voter list of 1955. That is not exhibited. Surprising.
Voters list of
1955.
55.
Yes, according to what he has submitted. Though it is not exhibited, neither it is stated in the ballot of evidence.
There was no mention.
Yes. So, the basic question is,
When did it come in? This thing only in the writ petition.
no, he has stated now, mother.
In the writ petition.
Yes,
In the writ stage.
yes.
See, this 55 voters list was not mentioned in the evidence. So it could not have come before the tribunal by way of affidavit, by way of as evidence.
Your Lordship, in written statement that was mentioned 1955. In evidence, is not.
There is no document.
There is no document.
WS it is.
That is not proven.
In editorial number 8, Lordship, in written statement.
There is no document. Otherwise, you'd have, see, mentioning a document in the written statement, you have to prove it.
Yes.
Lordship,
That
that
has-
was not Xerox
In a-
copy. I have initially mentioned.
That was a very important document.
Xerox
Yeah.
copy of
From your
1955
point of
voter list, Lordship.
What law point? The law is settled, my lord. What is pleaded, that has to be proved. The pleading is that if there is in the pleading, it is there in the pleading in WS that the father was the voter in 1955. That has to be proved in evidence. In evidence, they did not spell anything about the evidence. That line, that particular document.
Correct.
That is not true. So in absence of that, there is not a single document either of the petitioner or of the father prior to 1971. The basic question is whether the petitioner was there prior to 1971 or not. So even though there is a school certificate saying that he is the son of so-and-so, then also it is the duty of the petitioner to prove that his father is a citizen of India. Because as per para 26 of the Sabananda Sunwal, it is the date of birth, he has to prove date of birth, his place of birth. Second, thirdly, the citizenship of parents. That is very important. Because if you want to link himself to someone else, that he has to prove that that person is a citizen of India. Then only if he can link, he can say, yes, I'm a citizen of India by way of inheritance, by way of birth, because my father is a citizen of India. So that can be claimed. But there is no evidence at all that his father was there prior to 1971. That is the simple point here, man. Now, one document he was trying to brought into this record here in this petition, matter, but that is not there in the original record, man. That is one certificate from Tihu Town Committee, matter, page 61.
Yes. Town committee.
Page 61.
Nothing.
This certificate is issued on 21/7/2017. And it is issued by the chairman of the Tihu Town Committee. Chairman is not a government matter, the government authority. It's a selected person.
No, I mean, in any case, this is a certificate post the opinion.
No,
Post the opinion. Opinion, I think, oh no, sorry, it was before the opinion.
but this was not exhibited before the tribunal. কার্যালয়ের নথিপত্রে দেখা যায় যে মোহাম্মদ কাদির মিয়া মাঝি পিতা মৃত আসিরউদ্দিন মাঝি টিপু টাউনৰ ৩ নং ৱাৰ্ডৰ 257 নং ঘৰৰ 1964-67 চন ইংৰাজী চনৰ পৰা ধাৰ্য কৰা দেখা যায়. So this is the town committee election. Now I have checked the record, my lord. Record, the document is there, exhibit 9, my lord. Exhibit 9 is not that document. What Exhibit 9 has said here, 17/5/2000, This is the document of 17/5/2017 in the record. It says Tihu Nogor Committee অন্তর্গত 3 নং ওয়ার্ডৰ 1975 ইংৰাজী চনৰ ভোটাৰ তালিকা মতে ক্ৰমিক নং 310 খৰৰ 257 মহম্মদ কাদিৰ মিয়া পিতা সোয়েনসু কাৰ্যালয়ৰ নথিপত্ৰে দেখা যায়।
Yes, that was.
It's of 1975, not of 66, 70, 67, but this the document exhibited
This annexer, exhibit,
exhibit 9, my lord,
exhibit.
page 48 in the record.
Different date.
This is of different date.
17/21.
So page 61 document was not exhibited in the tribunal. The page 61 in the writ petition, this document was not exhibited in the tribunal.
And exhibit 9 bears a different date.
Exhibit 9 says in the 1975,
75.
the father's name is listed in the voter list of house number so and so. Probably this is, my lord, the town's committee voter list. This is not the voter list of election commission of India. This is, it has said Tihu Nogor Committee অন্তর্গত 3 নং ওয়ার্ডৰ 1965 ইংৰাজী 75 চনৰ ভোটাৰ তালিকা মতে ক্ৰমিক নং 310 ঘৰ নং সোয়েনসু কাদিৰ মিয়া কাৰ্যালয়ৰ নথিপত্ৰে দেখা যায়। This is as per the record of the, my lord, the town. So in all, my lord, there is no documents of the father of the petitioner prior to 1971. Existence of the father of the petitioner is not there. So if you want to link to father also, it will not help.
What about the school certificate?
Now, he has said that his existence in the school from 1970.
Correct.
So he is a citizen of India. Now, if your lordship may kindly see the school certificate, my lord, the first school certificate from 1970,
Which is exhibit.
that is exhibit 10 months. Exhibit 3. As your lordship has.
Which one? JB?
JB. This is the basis he's saying I'm since 1970.
Yes.
My lord, your lordship may kindly see, this is a certificate. What kind of certificate is this? This is not understood at all. Because it says, my lord, he admitted only নলবাৰী জিলাৰ বৰমা সৈয়দ শিৱনগৰ আব্দুল কাদেৰৰ পুত্ৰ পৱন আলী 1970 তাৰিখে এই বিদ্যালয়ৰ প্ৰতিবছৰ নামভৰ্তি কৰা আছে। This is the certificate, my lord, certified by one Jadaveshwar Goswami, প্ৰধান শিক্ষক শিশু আদৰ্শ নিম্ন বুনিয়াদী প্ৰাথমিক বিদ্যালয়. It was issued on 8/9/86. Months after the incident, months after the admission taken on, according to him, admission was taken on 21/9/1970. So after 16 years, this certificate is issued.
Please read again. Nalbari Jilar.
নলবাৰী জিলাৰ বৰমা থানাৰ টিপুনগৰ মহম্মদ আব্দুল কাদেৰৰ পুত্ৰ, there it is পৱন আলী 29/1/70 তাৰিখে এই বিদ্যালয়ৰ ভৰ্তি বহি নামভৰ্তি কৰা আছে। He has been admitted on that day. It is not that he has read in the school, he has passed out from the school. Normally, certificate is issued that he was a student of our school and he passed out on so and so. And the reason is given, my lord, why whether he has passed out or for any other reason, he has left this school. That has to be given normally in the school certificate. This is the normal format, but this is a different school certificate. It is specifically said that he admitted on so and so. Whether he read that is not, that is not there. Secondly, my lord, if your lordship, this is as your lordship has rightly pointed, this is a blank paper certificate where the school, my lord, name of the school is doubtful. In both, in Assamese it is said Tihu Adorsho Nimno Budiadi, but still it is said Tihu JB School. Partly the school certificate issued after my lord 16 years from the date of admission. We don't know when he has passed out, but he has said. And main thing, my lord,
It does not have a letterhead. That is a
yes,
problem.
it does not have a letter.
Otherwise, yes, the certificate says something.
Yes,
The deposition is also there.
Yes, I'll come to the deposition, my lord.
But
Secondly, this certificate is issued after, my lord, 16 years. And thirdly, my lord, in evidence, he has not said anything about this document. As your lordship has rightly pointed out, only in cross he said, yes, I read. Only in cross this document, my lord, this part has been revealed. Otherwise, in evidence, he has not said anything about this document. No, he has said that he read in this school or he admitted in this school. Your lordship has seen, my lord, the evidence of the DW1. Now, the deposition part of the headmaster who has come to the post, what he has said at page 66. I am the headmaster of Tihu Adelson Nimno Bunyadi School since 2008. So admittedly, he is not the writer of this certificate. No. Admittedly, he is not writer of this certificate. Exhibit in certificate was issued by the headmaster of the then headmaster Jadav Goswami. The OP Pawanali took admission in the town Adarsa Nimno Bunyadi School, Vidyalaya, in 1970 at the age of 5 in
plus core.
core 5 serial number 1970. So he has said at the age of 5 years, he admitted in core class. Exhibit 11 is the admission register. Exhibit 11.1 is the name of the student, Pawan Ali.
Exhibit 11.
Yes, 11 is the school
11,
register. School register is there, and 11.1 is
Exhibit 10 is the certificate.
Yes. Date of birth is not written in the certificate of Pawan Ali. Exhibit 10 in which year? Which year?
Just a minute.
Okay, please.
Sorry. It is clarified by the headmaster to the post. The date of birth is not written in the certificate of Pawan Ali. In Exhibit 10, in which year the pupil took admission in the Tihu Nimna Budyadi schools is mentioned in the certificate Exhibit 10. Now, my lord, the person who has come forward to the post, he is not the writer of the certificate. That is first of all. Secondly, he has not identified. He has not identified the signature of the headmaster. He has not said, yes, this is the signature of that. My lord,
But that may be a too technical a submission.
no, my lord, because the headmaster who has been deposed, my lord, he is not the headmaster who issued this.
But in the first line, he said, I am the headmaster of Tihu Adarkho Nimna Bunyadi since 2010. Exhibit 10 certificate was issued by the then headmaster,
Jadaveshwar Goswami.
Ideally, he should have said that
I-
whose signature I
Which I know.
Which I know. He has not said that.
Yes.
But he has uttered the name of
Yes.
Jadaveshwar Goswami.
Because
had-
it is written there, Jadaveshwar Goswami. So it can be seen from the record that Jadaveshwar Goswami is the issuing authority. But he has to identify that this is, yes, I know this is the signature of Jadaveshwar Goswami. Because, my lord, this is
What
not
about
his-
the register?
Register also said, my lord. The OP Pawan Ali took admission in the Tihu town Adarsa Nimna Bunyadi Vidyalaya in 1970 at the age of 5 in core 5 serial number so and so, Exhibit 11 admission register in the name of Pawan Ali. That is his statement with regard to admission register. Date of birth is not written in the certificate of Pawan Ali in so and so, and is not mentioned in the certificate Exhibit 10. In admission register, produce contents record of 1939 to 1979. The counter signature of the certificate of Deputy Inspector of School was mandatory. However, nowadays it is not necessary to obtain the counter signature. So counter signature is also not there. That was mandatory according to him. That counter signature is also not there. Now, my lord, this is the only certificate he is now relying. Otherwise, there is no document. And what is certificate? So this certificate cannot be accepted So, this certificate was rightly rejected for the number one, my lord, that there is no letter heading of the schools. This can be, secondly, my lord, the school certificate has not said that he continued in the school or he ended this. Only statement is that, my lord, he admitted. Now, on what basis? Thirdly, my lord, the school certificate was issued after 16 years from the date of admission. That is very important.
We'll just take a short break.
With regard to school certificates, I'd like to rely on the one judgment. my lord.
What about this school register?
That's why, madam, because the school register, madam, school register has also to be proved by the person who has entered it or who has given the information of that, madam, the entry. Either of the two persons. That is the position of Viratmal Singh.
Viratmal was on a different context, though we are
Yes.
citing or even referring to Viratmal. That was on a different context altogether.
It is part of the particular.
Exactly.
Whether that is correct or not.
Now, suppose there is a registrar.
Yes.
That person who had entered, he is no longer there, he has left the school or he has passed away.
Yes.
And will it be, or will that automatically render the register wholly inadmissible in evidence? No. It can still be proved. So who will prove in that case?
That is, madam, that has, madam, my submission is that has to be proved by the mother who is there, the mother, who is the custodian of that particular.
Correct. So this person, he was in custody.
Even in custody.
Hmm.
Now, my lord, that's why I'm saying, madam, while he got, when issuing that certificate is fraud, he has to identify, because, my lord, it may not be that school certificate may not be a genuine one. It may be the person who has issued that certificate, that may not be the same person who
Correct.
was the school head. That's why the identification of the minority signature is very much necessary. Secondly, minority, another aspect, minority, he has not, in WS, he has not mentioned his mother's name, any siblings.
Mother's name, no, not to mention.
Not there. Siblings are not there. So, whether Manat is Manat Mohammad Qazi, Mahdi or Mohammad Ali, that aspect is also not Manat doubtful. Because age discrepancies which relate to this school certificate, school document, and other documents are very much apparent.
Like?
Like Manat, as per the school certificate, he was 5 years when he was admitted in the school. But the certificate, if that is so, he was born in 1965-64.
Correct.
Somewhere said he was born in 1964.
Good.
If he was born in 1964, why not? He cannot be 28 years in 1997. He should have been born in 1969 or 70. If he was born in 1979, he cannot take admission in class 1 or at the end of 5 years in that particular skill in 1970. And this certificate, this school register, this register has not provided, my lord, has said that he has been issued such kind of certificate in 1985. This only says only one certificate was issued according to this register, my lord. Transfer certificate Prokafar Tariq. This school register says on 21/4/1975, this Boban Ali was issued a certificate with regard to transfer of this school. So, issuance of this certificate is not mentioned here. This is the record. Record reveals he had been issued a certificate only on 21/4/1975 by the headmaster. That certificate is not because the record says, madam, Boban Ali, so and so Abdul Kader Ali. All along his father name was there in the reference. We have to see the reference, madam. Reference, it is Boban Mahdi. my lord, son of Pawan, Abdul Majid, Kader Majid. And now he was admitted at the age of 5 years. He's there. 4 months training. Admission date is shown as 29/1/1970. And school error karon pass courses. School error karon he has passed this and transfer certificate প্রকাশের তারিখ 21/4/75. That means 21/4/1975. This is the only certificate issued in the name of police. There is no other certificate, no malad noting that any other certificate is issued against this name. So apart from those malad age discrepancies, apparent age discrepancies and the malad the school certificate was malad the unlike rely this judgment. But this is on matter the related issuance from also. This this is WBC 2294/2016. Hamida Begum.
Reported, not reported.
This is
2294 of 16.
16.
Name,
Hamida Begum.
Hamida.
Hamida.
H-
HMIDA. Hamida Begum.
paragraph, date of the judgment.
6/6/2018. 06/06/2018.
Might be reported also.
Reported.
Paragraph,
Paragraph 22, 24, and 25.
Hmm.
24 may be simple. The certificate can be of no assistance to the petitioner for more than 1 year. Firstly, as per the certificate, petitioner had left the school on 31/12/1989. The certificate was issued 13 years thereafter on 28/9/2002. Here after 16 years, the certificate is issued. Thus, belated issuance of certificate would naturally raise legitimate questions about the bona fide of the said certificate. And my lord, school record, my lord, here in this case, there is no noting that this certificate is issued in 1986. That part of the law on this point is well settled. School admission register is not a public record within the meaning of section 35 of the Indian Evidence Act. Therefore, it is necessary that contents of the school admission register would have to be proved. The contents of the school admission register have to be. Then Viratmal Singh has been referred here, my lord. Paragraph 25. Supreme Court has clarified that the stand of proving an entry in such a record in the same as applied in the criminal proceeding. In Viratmal Singh versus so-and-so, the Supreme Court has held that date of birth recorded in the school or school register would have no evidentiary value unless the person who made the entry or who gave the information relating to the date of birth is examined. That is the position there in Viratmal Singh. So only 2% can give evidence.
Suppose he's not there,
Yes.
not alive, suppose.
Then my lord,
Or can no longer be
found.
found.
Such persons entries contained in the school or certificate would have no probative value.
This is laid down in
It's Viratmal
Viratmal.
Singh, my lord.
Viratma, Supreme Court.
1988 Supply SCC 604.
The principles of section 32 Evidence Act would not come. The earlier
Yes.
high
That is
would not come.
yes.
The person is no longer there.
The school admission register is not a public record within the meaning of section 35 of the Indian Act. So that position, my lord, first of all, my lord, the belated issue itself created doubt in the school certificate. Secondly, from the record, it is said, my lord, the issuance of that certificate is not mentioned in the record. Other one certificate is issued in 1975, that is mentioned, but this issuance of this certificate is not mentioned. Thirdly, my lord, the headmaster who came to depose, he has not identified the signature. Had it been, my lord, mentioned also, that it could be a different issue. But it is not mentioned in the record that this certificate is issued. And the headmaster said, yes, so-and-so had issued that certificate. Because his name is there in the school certificate. It is apparent, it can be seen. But whether it is the original signature, originally his signature or not, or whether he know the signature or not, that is not the post. That evidence is not there. First of all, he has to know that, yes, the so and so is this signature belong to the headmaster, the then headmaster. Then only he can identify. So on this principle, on this principle laid down in this document, my submission is that this school, neither the school record nor the school certificate, apart from the discrepancies in the age, because as I have already said, if we compare all the documents, everything, everywhere the age is mismatched. Age is mismatched. If the school record is correct, the voter list cannot be correct. If voter list is correct, the school record cannot be correct. And another aspect, he has not, I don't know why he has not produced any documents of his parents. There is no documents of his parents, either prior to 1971 or after 71. There is no document of this. And lastly, one thing. If the age mismatch, your lordship will find page 41 is voter list of 1997. Petitioner's name first appeared at the age of 28 years. If he was born in 1964, his name should have been there after 1985. 85, 86, 89, 93, 96. At least all this voter list, his name should have been there. But there is no documents as such. The high school certificate is not good. That is, the Gauhati certificate has no value. Because even though Gauhati has come, in fact, it was a Panchayat certificate. In case of Panchayat certificate, Supreme Court has said the Panchayat certificate can be issued only for the married women. Only for married women to show that she got married and she has shifted from one place to another after marriage. So that is not a proof of citizenship. That is also clear. But only to prove that she got married and she shifted from this place to that place. And another document he has brought into here, the residentials issued by the district court. That is simply a residential certificate issued after 1971. Yes, it is admitted that he is residing there, but it is not a proof of citizenship. Yes, it's residing there, that is not a disputed question. So, in absence of reading about the particular reading of her reading that particular school in her evidence, this evidence matter. In fact, the document has no value at all. He has not stated, given any positive evidence, that he was reading at the school in 1970, and this certificate was issued by the then headmaster in 1986. That statement is not there in the my lord evidence. In this settled position, though, I would not like to realize just one judgment, because that is a point of material facts, especially needs to be disclosed in the written statement. The material fact that who is his father, where is his father, what happened to his father, mother? His father was there. What happened to his father? What happened to his family? Whether he has any sibling, this has to be disclosed. And if father is there, why his father is not there along with any returns or any document? That has to be there. So, in this judgment, this is 2017 to GLT Mallet 974.
974.
Yes.
Name?
Name Aftara Khatun. Aftara Khatun. This is certain. This is stated again and again. Era 12, it is stated. Para 12, it is said petitioner did not say when she was born. Consequently, there was no mention about her age. in this case, he has mentioned his date of birth, but it's not consistent. She remained completely silent as regard to his mother as well as about his brothers and sisters. Though she mentioned Mohammed so as her husband, she did not mention when she got married and whether post-marriage she had any children. When one's citizenship is being questioned, that to by step, one has to disclose all material facts which are within his personal knowledge to prima facie establish his citizenship of India. Where are thereafter required to be proved by adducing chosen reliable evidence, failure to disclose such material facts at the first instance itself, that is, in the written statement, which is the basic defense statement of the
You're reading paragraph?
12 months. May lead to a drawing of adverse inference against the proceeding. Moreover, it is well settled position that a party cannot traverse beyond the pleading. What is pleaded can only be proved and not something which is not pleaded. So that's my submission, but the tribunal has committed no error by declaring the petitioner to be fraudulent on the basis of the material available of record.
Yes. Any reply would like to make?
The contents of the admission register, Lordship, that was since 1939 to 1979. And that was in the custody of the school authority, Lordship, and that was produced before the learned tribunal. So any tampering or any illegality done by there is no chance, Lordship. That cannot be a question of any doubt, Lordship, regarding admission register. And school headmaster clearly stated that Exhibit 10 certificate was issued by the then headmaster Jadaveshwar Goswami, Lordship. And there was no suggestion that this certificate from the government side before the tribunal, that there no suggestion that this certificate was fake or any infirmity. There was no any suggestion, Lordship. And that school admission register was properly, Lordship, exhibited, and that was proof as per law, Lordship. And the petitioner is very established that the petitioner is the resident of the Tihu town since 1970.
Residency, staying there and citizenship are different
That is
issues.
different, Lordship. In the
We are
very,
more looking into aspects
No, no.
or evidence which will prove your citizenship.
at the very initial of my submission, that petitioner could not establish his citizenship through his father, Lordship. That was I'm very initially stated, that, Lordship. And one aspect is that
So you have to, if you have to stand alone on your own legs, then you have to have convincing evidence in your own name. The only evidence that you have produced is the school certificate.
school certificate, other documents also is name.
Other documents are post. The 97 voters list, these are all posts. You say that you are born prior to 1971.
Lordship.
So if you are born prior to 1971,
Lordship.
your age would be a determinative factor
Lordship.
to show that you would fall outside the ambit of this reference. Isn't it? Now, how have you proved the age that you are born in 1964?
There was no school birth certificate, Lordship, but
That is it. So we have to, from the evidence materials
from
available before us, we have
from
to
the-
ascertain your age. You say you are born in 65.
Lordship.
So if you are born in 65, we have to check, we have to examine that aspect from the materials available before us.
Lordship, in 1917, he was admitted in school in 5 years, at the age of 5 years. That is proof that he was born in the year around 1964 or 65, Lordship.
Okay.
And it was admitted that, Lordship, the evidence and written statement was not properly drafted, Lordship. That was lapse on the part of the youngest advocate, Lordship.
Okay. We close this for judgment. Hearing is concluded, huh? Now public debate. Okay.
No, prosecutor. Right, officer. Masuk itu.
Item 8, Mr. S.C. Biswas, Mr. Hassan, F.A. Hassan, they were seen in the court. Nineteenth matter, if there is default, we'll dismiss it. We'll call this again at 2 o'clock.
I think 10 to 15.
The appeal has been filed by SEBI. Before the learned single judge, my lord.
It's a writ appeal.
It's a writ appeal.
Why is it come today? For hearing?
Well, my senior is coming, my lord, he will argue. He will know.
Let me play the facts.
Hmm?
Till the learned senior is coming, my lord. In fact, my lord, focus notice was issued, my lord. Against the petitioner, respondent here.
You were an employee.
No, my. I am involved in my lord share transaction.
Okay.
In case of my lord intraday share transaction, my lord, it is not permissible. So penalty is liable to be imposed upon me. So we are not on that, my lord. We are on the non-compliance from the statutory provisions. While issuing this statutory, my lord, so cause more. Hello. Learned single judge, we have advanced, my lord, a number of, my lord, points before learned single judge. My single.
A so cause notice has been challenged, Lordship, issued by SEBI. And seven issues were framed, which Lordship will find it 495 page number in the impugned judgment.
Page
495.
495.
495. So cause notice on page of the 131 is the so cause notice.
$495.
Without responding to the so cause notice, Lordship, they have straightway come and challenged it. So that is at page 131, the so cause notice.
Now, where is the impugned judgment?
Impugned judgment starts at Lordship, page effective 456.
456.
456. 449 is the first page, but the judgment starts at
There
456.
were a number of cases.
Series of cases are there.
Okay.
And why I am taking this honorable court to the issues, because some of the issues came in favor of SEBI also. So therefore, Lordship will have to adjudicate the issues which were delivered against the authority, that is the board. The first issue is, Lordship, whether the ground to believe in which is a condition precedent of initiating
You are at page?
495
The issues.
issues.
495 issues.
Whether the grounds to believe, which is a condition precedent of initiating an investigation under section 11C, did exist in the facts and circumstances of the present case, and this issue was adjudicated in favor of the board, Lordship. So I have no grievance against this. Number two, whether the opinion to be formed under Rule 3 of the PR 1995 is an individual opinion in respect of the person specific against whom the notices under Rule 4.1 are to be issued, and if yes, whether such individuals' opinions had been formed. This issue has been decided against us. Then issue number 3, whether a notice under Rule 4 of the PR 1995 can be assailed in a proceedings under Article 226 of the Constitution of India. It also went against us. Whether the adjudicating officers appointed for
Captain
the
Free has been said that it can be challenged.
it can be assailed, yes. Whether the adjudicating officer, but I'm not on much on that because whether it is before this forum or any other forum, we have to argue over case on merit. Then Roman 4, whether the adjudicating officers appointed for the purpose are the respective divisional chiefs, it is yes, so it is in our favor. 5 is also in our favor, whether the appointment of an officer not below the rank of a chief division chief to be the adjudicating officer was done in accordance with the requirement of section 15 subsection 1 of the SEBI Act 1992. It is also in our favor. The core issue is, Lordship, 6, whether the individual opinions formed against persons specific with reference to Rule 3 of the PR 1995 are required to be provided to the notices, and in the present case, whether it has been provided. This issue has gone against us. And the last issue is also very critical because it has a pan-India ramification. Whether a notice under Rule 4.1 of the PR 1995 can be a composite notice requiring the noticee to respond to whether an enquiry should be held under Rule 4.1 and also requiring the noticee to respond under Rule 4.3 as to why any of the penalties contemplated under Section 15A to Section 15HB should not be imposed. So whether in the same notice, whether we can say that a enquiry will be conducted against you, that is one, and whether we can impose a penalty of such and such provision. Can that be in one notice itself? That is where the learned single judge has committed a major violation, because if Lordship is pleased to look at page 131, page 131, the notice is under Rule 1, not 4.1 or 4.3 or 4.5.
131.
Page 131. The issue notice was issued to Ankit Diwania of 17 September 2021. Lordship will see the heading. Notice under Rule 4. It is not under 4.1 or 4.3. So in any case, Lordship, the Lordship will definitely adjudicate it. So therefore, framing of the issue itself is faulty. It is not a notice under 4 sub Rule 1. In any case, Lordship, one vital aspect is that Romans issue number 6, whether the individual opinions formed against the person specific with reference to Rule 3 of the PR 1995 are required to be provided to the notices, and in the present case, whether it has been provided, that issue. And other issue is Roman 2, whether the opinion to be formed under Rule 3 is an individual opinion in respect of the person specific against whom the notices under Rule 4.1 are to be issued, and if yes, whether any such individual opinion has been formed. So whether we have formed that opinion or not in our records, we have to see and we have to place. We did place the records. The learned single judge was of the opinion that that is not sufficient, but that is not part of the record. So initially there was some reservations of our authority that whether we should file it in the form of an additional affidavit. Today, the officers have come. They could not come because of the flood situation yesterday. They have reached Gauhati this and this. They have shown me all the records. So if Lordship permits, then I would like to file a very short affidavit of that of note sheet and the materials on the basis of which the opinion was formed. And Lordship will have to see it because
What prevented you from placing those before the single judge?
it was not placed at the earlier time.
But it was existing.
It was existing. It was still in existence.
The records were placed before the honorable single
Court, but
judge.
learned single judge maybe either not looked it from the right perspective or maybe may have ignored the records. There's a finding, there is a direct violation. There no record was there regarding opinion formation. There was categorical opinion formation.
Can you have a look at the record?
Yes. I have prepared for court also and for us also.
No, just paraphrase, I want to have a look.
Yes,
at
yes,
the-
Lordship. That 3.1 onwards. That's not it. 3.14%.
Page.
Just 1 second, Lordship. Yes, Lordship will find that at page 215.
215.
215.
What is it?
How the investigation carried, the investigation was placed before the authority WMP. A committee was constituted. That committee consisted of 5 members. They have deliberated. There are batches. Actually, identical transactions were made and there were 2-3 batches. So they have finally opined that a proper inquiry should be conducted. And they have also said that that committee would apprise the SEBI board also, which are as per the procedures under the SEBI Act. So this should be part of the record, Lordship.
What is that? This file noting that 217? As
7 submitted for approval, please. So before that,
as suggested.
as
in-
suggested. So
Hmm.
if Lordship is pleased to come to 3.42 to No.
Mr. Goel, I think you would have like to have a look at this.
Yes, Lordship.
It will have, it may have an impact on the adjudication process.
Yes.
Let it be put on record by way of an affidavit, so that you also are in the know of what is going on. But this pending since long. How soon can you file the affidavit?
I'll file it because the officers are here. I can file it, place it in 2 days time, Lordship, the affidavit.
Okay,
By
then
Monday, we'll file it.
you can place this on Thursday.
Next Thursday, Lordship, may
Next
place it
Thursday.
in matter.
Are you, Mr. Goel?
Page 192 also is very relevant.
I think.
Thursday, we had fixed that other matter, but
Then thereafter, Lordship, not in the 2nd week of August. Then in
we have a convenient date for both of you.
yes, Lordship.
That land acquisition matter perhaps. will
Lordship
be
may keep the
required.
matter as part heard. So
No, not part. This is a very temporary bench.
Temporary.
in
only
fact,
for
I
two-
wanted to do this on various occasions.
Only 2 days,
Because-
2 days we are sitting.
In that case, Lordship may come on in.
Thursday, we have fixed those land acquisition matters. Aero City or something. Thursday, I think.
That matter may not come here, Lordship.
No. It will come before DB2.
DB2.
DB2 only. Yeah,
Then-
this is a very temporary arrangement.
On Thursday, next Lordship is sitting.
No, we are not sitting. We are only sitting for 2 days.
Today and tomorrow.
2 days.
Then later let it be taken up tomorrow. We'll file it today itself.
not in a hurry. It's a very temporary
I
arrangement.
have to also examine my after filing.
You file it within 2 days. We'll
Then
have it-
Lordship will give us 1 week's time to file, then let it come on usual course in that manner.
We'll fix a date. Nowadays, we'll fix it.
Then Lordship would be pleased to fix it after 15th of August.
Mr. Goel?
Mike.
Okay.
For me,
Heard Sri D. Saikia, Learned Senior Counsel assisted by Sri B. Gogoi for the appellant. Also heard Sri A. Goel, Learned Counsel for the contesting respondents. All the respondents. In all the cases. All the cases.
sole respondent,
Respondents. There are many cases.
all right.
Respondents in all the cases, all the appeals. Where Sri Saikia, the Learned Counsel, Senior Counsel has submitted that though the records were produced before the learned single judge, comma, it appears that the same was not looked into in the proper perspective. Full stop. He has specifically referred to the records pertaining to issue number 2.
Yes, regarding formation of opinion.
Issue number 2, which was framed in connection with formation of individual opinion.
Lordship.
Full stop. He has submitted that interest of justice will be served if the aforesaid documents are put on record by way of an additional affidavit by serving copies to the other side. Full stop. Para. The submissions made appear to be reasonable, which is also not opposed to by Sri Goel, the Learned Counsel for the respondents. Para. Let the additional affidavit be filed to bring on record the relevant documents pertaining to formation of individual opinion. Let such affidavit be filed within a period of a week, and the matters and the appeals be listed on. We'll have it on after 15th,
Yes, Lordship.
on 18th of
August.
That's a Tuesday,
Lordship.
18 August.
Highly obliged.
You can take this back.
Lordship.
May I plead your lordship? Lordship, as per the instruction of my client family member, my lord, the petitioner was died. Yes, lordship. Yes. Yes, lord.
This one on three.
Is this in the court? H. Gupta, CGC.
Blush.
Draft Mari Dipa, huh?
My lord, here in this case, I have challenged the virus of section 7. In the meantime, my lord, they already amended the act and rules, so I am not pressing this petition.
Heard
The pleasure
Sri R. Islam, learned counsel for the petition has also heard. Sri D. Sekya, learned AG, assisted by Ms. P. Barua. Madam, you are for? Or, Ms. Dr. P. Agarwal appears for the as per number 7. Full stop. By means of this petition, comma, the virus of which act?
My lord, Assam Cattle Preservation Act 2021.
Assam Cattle Preservation Act 2021 was put to challenge. Full stop. The Learned Council for the parties have, however, informed that in the meantime, there has been an amendment of the said act and full stop. Sri Islam, the Learned Council has submitted that in view of such amendment, comma, there may not be any necessity to continue with the present challenge. Full stop. Writ petition is accordingly closed.
Much obliged.
Item number.
No, this is an appeal, my lord. This is the order passed by the learned single judge. The basic challenge here is not under the rules, my lord. The learned single judge while interfering with the order of removal.
Where's for the other side? Item number
18,
18.
the name is shown, my lord.
Yes, who's the word new counsel?
I think my lord, Mr. Gogoi,
D. Gogoi, Dixit Gogoi.
Dixit Gogoi, my lord, he was appearing, my lord.
I think his presence would be
My
necessary.
lord will,
Can you inform him?
yes, I will.
After a while?
After a while, my lord.
Until 19.
19. States appeal. Oh, perhaps this court will not like to take up.
I just doubted whether a bit of. I thought, but I have gone through it.
This is before any other bench without one of us, bracket from moment.
Item 21.
Included appeal.
Lord, here the basic issue there in the appeal, my lord, whether against the government land.
Students, you please take a seat. There are seats vacant. Don't stand.
My lord, whether against the government land, my lord, there can be any compensation awarded. My lord, my lord,
They were occupying government land.
yes,
And
and my lord, the
evicted.
no, my lord, the learned single judge, my lord, awarded, directed to pay compensation
For?
for the government land. My lord, here what has happened, my lord,
No,
the
compensation for what? They have been evicted from this land.
acquired, not acquired. There has been no acquisition, my lord,
No,
formal
no,
land.
compensation in lieu of what? Eviction.
No, in fact, what has happened on the background facts, my lord, if I may submit, my lord, there is a project, my lord, Bogeybill project, my lord, for construction of a service road, my lord. Certain lands were acquired on temporary basis, for which, my lord, the railways have paid lease charges. An agreement was entered between
Almost requisition kind of a thing.
my lord. And then those lands were returned back, my lord. Thereafter, my lord, after 10 years, my lord, another set of writ petitioners, my lord, they approached the learned single judge, my lord, praying for, my lord, land acquisition. compensation. Now, my lord, that order was,
Their lands were also requisitioned or used.
they were on the government land, my lord, in fact. They were in the
Or it was
government.
not patta land.
Not patta land. Now, on the government land, my lord, there can be no direction to pay.
Yes.
There is,
Not, actually not correct, my lord. So, this, my lord, part of those lands were annual patta land, my lord. This occupying this land, my lord, since 1971, my lord.
Whenever, whatever it might be, if those are government land, how do you get
No,
compensation?
my lord, but my lord, the name of the petition is, my lord, shown in the, my lord, exam in Jamabandi also. So
the,
it cannot be said that they are the illegal encroachers or my lord, they are not occupying them. And my lord,
Jamabandi on the strength of what?
the moment of the same land.
On the strength of what? Your names had entered into the Jamabandi. On the strength of what? What was it? What was your title to the land? Where did you, from where did you gather the
Because,
title?
my lord, at that time, my lord, it's not paying, my lord, project to Dana.
Tozi is a fine.
Fine.
Is an encroacher.
And my lord, but my lord, some of them has also, my lord, given patta also. Some of them has given patta in the,
Who has been given patta? Show us.
yes, my lord.
How many petitioners are there?
There are total 151 petitions, my lord. Out of those 151, my lord, I have an idea of about 32 was, my lord, the patta, one of the patta land.
Patta holders.
Yes, sir.
no, when they acquire that patta, my lord, that has to be seen. When we requisition the land, my lord, to those patta holders, we have already paid.
No.
Now we have to see from the context when the requisition had taken place. If the
Subsequently, my lord,
pattas have been acquired later, this will not
That's
make
what-
any difference. If we are patta holder at the time of requisition, then
Yes, at the time.
then only you may have a case. Otherwise, you will not have a
Yes,
case.
at the prior to decision, some of them have the patta, my lord.
Now, how do you get? Have you made any table chart kind of a thing?
But the affidavits, my lord, filed before the learned single judge by the deputy commissioner, that clearly states they are encroaches.
No, no.
That is, there is a categorical statement, my lord. I will page,
One the same revenue authorities, my lord, also
page
pardon,
172.
my lord, that they were just submitted the affidavit that yes, railway to deposit the compensation, and my lord, this include order was passed with the consent of the.
Okay, let us come back at 2 o'clock.
My lord.
But if it's a government land,
But it's not the good, my lord.
Lordship has even decided, my lord, the matter was referred to larger bench. There is a order
Which
passed
one?
by the learned, my lord, we have an exact order. There is an order.
what did we decide?
My lord, that on the government land, my lord, there can be no compensation or section 17(3) of the Land Acquisition Act.
1894.
1894. That matter was referred to larger bench, my lord, and then the larger bench affirmed the finding that, my lord, even Zirat cannot be given.
Okay, we'll place that.
My lord.
Report it going to break, I would not be here. There is one matter of chief has been yet now, on board now, 2021. I am appearing on behalf of certain a group of respondents. My learned friend, he and Mr. Gore is appearing for the others. And he is the appellant state. Railway.
Where you have been granted compensation
Yes.
for occupying government land.
Yes.
How do you get compensation for government land?
And I will come to it, my lord. But then my first objection is whether this appeal is maintained.
Appeal is maintainable. Why?
Because it was on admission. They agreed that they will pay. We will pay to the state authority, that is the revenue, the deputy commissioner. Deputy commissioner.
Is it recorded in the judgment?
So the appeal has us not only once, twice. What you will see, the first when this petition was allowed, they went on appeal. After few months. Why relatively?
Some other petitions were allowed
No, when this petition was allowed.
initially. Okay,
Initially.
they had filed an appeal.
Yes, the railway authority went on appeal, though relatively, they went on appeal. After 252 days, then they had withdrawn it and went for review.
Review. Okay.
By this time, the when the review was heard, the learned judge who passed the order has already retired, but it was heard by 100 times. And there also, the review order also very categorical that there is nothing which leads to the review. Because the finding or the statement which was recorded by the learned courted bench was perfectly honest. And therefore the review was dismissed. And then they agreed that yes, we are paying the amount. There also the learned counsel appearing, who is appearing today, on behalf of the railway, submitted that we are paying the amount to the developer. No issue there, no problem there. Thereafter, they have come on appeal again after so many months, and there was a stay order apparently, and therefore the money has not been paid. My objection is, since it was an order passed on admission on 2 occasions, therefore this is not maintained. Firstly, Lordship will come see. I will take your Lordship to the examiner. What is the order? How was it recorded? Page 298, relevant part. Short order, my lord, I will just read out.
298.
298, is it applicable?
Yes.
Now, first part, Lordship will say so and so, so and so, so and so. Part, and railway council was there, he was also heard, so and so, senior governor. Two, without going into the details, it would be sufficient to take note that the claim of the petitioner is that the land which was under their occupation was taken over by the railway authority for the purpose of construction of certain service roads for the railway line. But no compensation in lieu thereof has been paid. After a detailed deliberation, Mr. Kinkor Das, Executive Engineer, Construction, Pasida, Railway, upon verification of the record, makes a statement before the court that the land of the petitioner was utilized by the railway authorities for the purpose of the service road, but no compensation thereof had been paid. That was the statement. And accordingly, Mr. Kinkor Das makes a statement that the railway authorities will give appropriate consideration to the matter and ensure that whatever compensation the petitioners are entitled under the law will be paid in lieu of land that has been taken would be paid. It doesn't say that this much amount for that purpose will pay. It says, yes, but land was taken, land was utilized, it was under their occupation, and therefore they say that railway authorities will give appropriate consideration.
Yes.
Appropriate consideration to the matter and ensure that whatever compensation the petitioners are entitled under the law to be paid in lieu of the land that has been taken would be paid. That was the statement made. Very innocuous, in that way, because whatever is probable, we'll have to just think out, find out what is it. A stand is taken by the railway authority that the land of the petitioners is a government land. And you see, in this respect, we take note of a communication dated 26/2/2016. Is the Annexer X7 here. From the Deputy Commissioner Dhamaji to the Deputy Chief Engineer, Bogibi, his project, Tilapatra Dhamaji, providing that certain land have been used for construction of service roads from Kulajan to Karenghat, Bogibil project, but in respect thereof, compensation have been paid to 53 affected landowners, but another 148 landowners have been excluded from the benefit of payment of such compensation. Accordingly, the deputy commissioner estimated an amount of rupees 9,93,620 for renewal patta lands that have been utilized by the regular authorities, and another amount of rupees 36,79,300 in respect of another 219 bighas, 4 kathas, 16 lakhs, which apparently appears to be government land under occupation of the respective landowners. We are there, my lord, for more than 70 years. Has come to the background of the landowners. Since 71, since 1971. And this is a tribal belt. We are tribal persons. We have the right there, and that's how we are there. And the authorities has termed us as landowners. I will come to it. Accordingly, a request was made that the aforesaid amount be released at the earliest.
No, Mr. Mohanto, since we have not heard Mr. Gupta,
Yeah.
we are not going into the merits. We
Yes.
just need to point out where is the admission so that we can give our
Yes,
consideration
on the
to the aspect of the maintainability of the writ appeal. Yes.
Now, therefore, kindly this paragraph 5 I am reading. Let me
Yes.
complete it.
Yes.
Accordingly, a request was made that the aforesaid amount be released at the earliest. The railway authorities response thereof by their communication dated 29/16 from Yaspal Singh, Deputy Chief Engineer, Construction 1 NF Railways, Silapathar, had informed the Deputy Commissioner that the land was taken on temporary lease for the service road from Kulazan to Bogeyville. But in respect of such temporary leasing, the railway authorities can give a compensation either to the individual patta landholders or to the government for government land. If it is the stand of the railway authorities that in respect of the government land under occupation of the respective landowners, the railway authorities will pay the compensation only to the government and not to the landowners, be it so. Be it so. But let the appropriate compensation be deposited, appropriate compensation be deposited to the government.
No,
That is,
if it is the stand, the sentence starts with if.
yes. If it is so, that means they want to pay it to the
If it
government.
is the stand of the railway authorities.
Yes,
It will pay to the government.
government. It is the standard. They have referred to, Ladies Jadhav referred to the letter also. That is 29/2/2016. Against that they have written. And therefore, I think now, can you see here, accordingly, as paragraph 7. Paragraph 7. Accordingly, as agreed upon by the concerned official of the NF Railway before the court, the Deputy Chief Engineer, Bogeyville project, to do the needful to pay the amount required by the Deputy Commissioner in the communication dated 26/16. And in
Mr. Mohanto, this matter is at the stage of final hearing. This has been admitted on 22/7/2025. So on the aspect of maintainability, perhaps we will not go. This was this point was available to you at the time of admission. It has been admitted for final hearing. We'll decide on merits.
Including the aspects of maintenance.
Because this, it has to be decided on a threshold, whether appeal is maintainable or not.
Yes.
If it is admitted, that stage is over.
That point was argued, my lord, in fact.
No, we do not know whether, and one more thing, it appears that the courted bench headed by the Honorable Chief Justice has given extensive thought to this matter.
My lord.
Let it be listed before that court.
My lord.
If we just check the order sheet, and it was in fact listed for further hearing on a number of occasions.
That was raised because
You have this before this.
that question to the other side.
Yes.
That having admitted, how can you come?
Yes.
That was the point raised, because
Correct.
this was raised, and then when this was moved after a long time,
Yes.
there was no caveat from our side. Therefore, they got the stay order. But when we appeared, we raised this point already. Then court said that all, and let us hear it.
No, but there was a condonation of the delay condonation application of this.
It was a-
Did you contest the delay condonation?
No, my learned friend was there.
Oh.
Then They said that we are not contesting, we'll go on.
No, you had appeared. So at this time of admission, you were there.
No.
The maintainability issue was not raised.
We were not, sir.
They have argued, my lord.
But no,
Some
you,
of them.
you means you are a colleague, and if anybody is there, we'll
One
not.
group was represented.
We'll have this before the appropriate same bench. Heard Sri H. Gupta.
If lordship likes it, I don't say no. But
No,
then there is no-
not one order, Mr. Mahanta. There are many orders.
I see.
To arguments to continue, re-notify and pre- that we have said. Okay.
Yes, yes.
Ah.
Yeah, it was there.
Heard Sri H. Gupta, learned CGC, appearing for the appellants. Also heard Sri K.K. Mohanta, learned senior counsel, assisted by Miss N. Begum. You are for
He is also for a group of respondents.
as well as Sri D. Sekya, appearing for the respondents who were writ petitioners. Para, the appeal appears to have been heard at length on a number of occasions by the coordinate bench headed by the Honorable Chief Justice. Raised to list this case. In the interest of justice, raised to release this case before the appropriate bench for hearing. P. Sharma for State Council.
That aspect is linked. It's linked. For final adjudication. No, I don't know. We are fine with some stuff.
Yes.
Item 18. Item 18 where I gave for the respondent counsel. I was served a soft copy of the memo of appeal matters. I tried to with software and updated liquid text. I could not do one, so I'm requesting a hard copy provided.
It was given, my lord, earlier, a different council was there.
Okay.
Change
What was the matter about?
This is, my lord, the removal from service was interfered with, my
Was
lord.
put to challenge.
Yes, on the
And
ground
then
of
it-
fake certificate, my lord. The employee has entered into service, my lord, by
Fake certificate.
submitting a fake certificate.
You initiated a proceeding against him.
Yes, and with
Proceeding culminated in removal.
removal.
That was the subject matter of challenge.
No, Leonard Singhal judge-
Successfully challenged.
No, Lord. Leonard Singhal judge
What are your grounds?
my lord, Leonard Singhal will interfere on the ground that the rules which have been followed is, my lord, not applicable, and it is the CCS rules which will be applicable. My lord, in our humble submission, my lord, the CRPF rules will be applicable.
No, that will be on a technical aspect.
On that ground itself, the
On
my lord,
substantial, all opportunities were granted to him.
yes, all opportunities were.
There's a specific document which they allege is fake, but it was never a part of that so-called process file. They, behind my back, they initiated a preliminary inquiry. They obtained a direct communication from a certain directorate of schools manner, which said it was fake. But that was not laid down according to the procedure followed in.
No, that may be a preliminary satisfaction to proceed against you. In the DP, in the inquiry, was the suspect proved that it was a fake certificate?
But since the document was never brought on as a part of list of documents, man, so there was no occasion to prove it.
You did not prove it.
No, my lord, there is a conclusion, my lord. There was an inquiry, my lord, the Registrar Board of Secondary Education, Assam, my lord, he has verified it and came to a conclusion that this certificate is a fake certificate. What else is required, my lord? That is
No.
not put to challenge by,
No.
they have never questioned that, my lord.
No, see, you have acted upon certain finding
My lord,
in a disciplinary proceeding.
my lord.
Now that finding, the person who had given the finding, did he come? Was he
It was
examined?
in, yes,
He was examined.
no, the officer was not examined, my lord, but the validity of the certificate, my lord, was
Put to him.
it was put to him. He knows this fact that the documents have been sent for verification
This is the
and the authorities have in writing confirmed that the certificate is fake. Thereafter, my lord, it was for him,
what post?
Constable
Constable.
GD, my lord.
generally.
You have been reinstated now.
No,
have been-
yes, reinstated, madam, but with a direction that they can proceed against me. Holding me in force, madam, with the.
New set of rules.
Yes, madam.
But you are insisting that you have
CRPF
followed.
rule is applicable. In fact, the judgment which has been relied by the learned single judge to come to a
But Mr.
conclusion.
Gupta, that option is still available to you. If you fail, you can proceed.
But my lord, the entire period has now been directed to be counted. That would be, my lord, we have to pay the arrears and even count the entire service maybe for pension. Whereas he has not
You have
worked.
retired. You have retired.
No, madam, I have a.
He,
age.
he has the age, my lord, but the service for which he has not worked, my lord. The entire
Well,
period
we
is.
can take care of certain aspects regarding the back wages, but so far as fitment is concerned, if it is interfered with, at least he'll get the fitment and other benefits of his seniority and notional benefits.
But on the-
those you can.
But on the aspect, my lord, whether he has been
That
rightly
is on an
removed
aspect
under the service rules.
besides the merit. If you go into the merit, then we definitely go.
My lord.
Yes, when Mr. Google.
Well, as he's given me a hard copy, madam, I'm otherwise.
Today itself, I will do.
Heard Sri H. Gupta, learned CGC, appearing for the appellant. Para. Sri D. Gogoi, learned counsel
Sole respondent.
for the sole respondent written petitioner, has submitted that though soft copy of the appeal memo was served, comma. A hard copy may be furnished to him. Purta Sri Gupta, the learned CGC, has readily accepted to serve a hard copy during the course of the day. Para. List for hearing on
Once I'm hearing next week, madam.
we'll have it on 6th of August. Is it okay?
My lord.
Thursday?
The interim order ideas will continue.
Is there any interim order?
Yes.
No, there is no.
Interim order passed earlier to continue in the next set of listing.
My lord.
All right.
Please hold it.
Withdrawal, my lord. Tomorrow, if maybe.
This bench will not be there. It's a withdrawal. We make a prayer before the appropriate bench. Okay.
My lord, another, my lord, for listing, my lord, on
This
Monday.
this is a very temporary bench for tomorrow, today and tomorrow.
Right.
Make it before the appropriate bench.
Obliged.
Item 1 to 22. But here, if I may just point.
All the matters we have to take up separately, I think.
Yes, that is.
One by one we'll take up. Which-
To submit.
Yes.
The state has not filed any review petition, at least that has not come before this court curriculum.
Regarding which matter?
Clients,
Okay.
against the first writ petition, which is the best. Where the order was basically considered and fought down. And they want to say that in some of the cases, other petitions, facts are different from me, which were tagged along, and therefore the common judgment came. If they indicate that against my class, the order.
Yours is under item number?
My.
Item number? 10.
Contact.
No, he said first case you have said.
Against us, no review.
Okay.
That's what I'm saying. Against us, contempts are pending, and they pointed out that a review is pending against some of them respondents, and it is a common judgment therefore. So they say that therefore we are not implementing. That's how we are before you. In fact, they have not filed any review petition against us specifically saying that this is here different.
Just a minute, we'll just clarify. Mr. Khataniar,
Yes.
have you got what Mr. Senior Counsel is-
Yes, madam.
that you may have good grounds of review
Yes, madam.
qua the other cases.
Yes, madam.
But so far as Mr. Mahanta is concerned,
Yes.
You have not filed any review.
No, my lord, we have not.
Meaning thereby that you are not, and the judgment is attained finally so far as their clients are concerned.
Yes, my lord.
So in that case, either you comply or you face contempt.
Contempts are there or
Contempts
And
are listed.
no,
along
no,
with the-
you
yes.
face contempt.
Yes, yes.
Contempt proceeding will initiate and will decide the contempt cases.
In that,
Now, what has prevented you from complying with the orders so far as those cases where you have not apparently filed any review?
till date, my lord, no review has been filed
Then,
in respect
then
of
there is no excuse for not to comply.
that, my lord.
Even mere filing of review may not be an excuse, but we have seen
Yes.
that there has been
Some-
interim orders
Yes,
also in
yes.
few of the cases not to go ahead, only to give you an adequate chance to argue and if possible, make out a case for review. Otherwise, the judgment will stand.
Yes,
it's
ma'am.
of 21, man. Judgment of 21, we are in 26.
But what is the reason which would you would take as a defense so far as the contempt cases are concerned?
Otherwise, my lord, since we have not filed any review, we cannot take any other defense, my lord, here. But those cases are tagged along with the other review petition, my lord. So may I plead, my lord, that this review petition may be hard and may be decided, my lord.
We are deciding the review petition.
In the meantime, my lord, in the
Review
in
has been
respect-
filed in how many cases?
review has been 10 or 11 cases, my lord.
The grounds of review are the same.
In those cases are same, my lord.
And then we can.
All are, my lord, authorized at the time of last date of
But
submission.
Mr.
of case.
Mahanta was not authorized.
That, my lord, in fact, today I cannot say, my lord, but maybe.
No, since you have not filed the review.
Yes. There am
For you, it will be difficult to take that stand.
Yeah.
That if that stand was available, definitely would have filed the review.
Yes, my lord.
So we may infer or presume that the stand is not available.
That was what was submission the last time indicated. That's how I can remember. So therefore, my lord, here, Lordship may, in the contempt also, Lordship may say that this case, they will comply and report. Else, Lordship will initiate contempt also.
Let us make an endeavor to hear the review petitions.
Yeah.
You're also in some review petitions.
No.
You're-
I'm in contempt. Therefore, I'm.
You're only in the contempt.
Yeah.
Who appears for the review?
The first review, I'm pressing the first review, item number 5, my lord. This is the first review filed by us. my lord.
Item number 5.
Item number 5.
It's not.
Review as
We are more in this.
item number contempt. Contempt. You are at par with your senior colleagues. Okay, we'll hear the review first. Okay. And which is the first review?
Item number 5, my lord. It's,
5.
Review petition 121, 2023.
So, my lord, my presence may not be required.
Okay, for the timing may not be received. You can have your colleague, your associate be here.
Yes.
Who is for item number 5?
My lord,
Mr. Laskar. All the reviews are on the same ground.
Almost same ground, my lord. There may be 2 or more grounds.
Can we
here
have
and here and there, my lord.
we
Yes,
can make a. Which items are for review?
Item 5. Item 4.
4, who is for 4? 4 is also review.
4, my lord, no, none has appeared.
None has appeared, okay. 4,
Then 5,
5,
6, 7, 8, 9. Then, my lord, 16, 17, 18, 19, 20, 21, and 22.
The writ petitioners are represented in these cases? Not in all the cases?
Not in all these cases, my lord. In item number 20, none has appeared.
Mr. Laskar, you are for?
I 21
Just a minute. 4, none has appeared. J. Laskar for 5, 5, 21 and 22. And And yes, you have appeared for
17.
17. Paul Oscar,
Yes.
only 17. And madam? What is your name? No, you're there. Your name is there. P. Kashyap. Only for 19. That means we have contest in 1, 2, 3, 4, 5 matters.
Yes, my lord.
Others they have chosen not to appear.
Yes, my lord. In one case, in item number 6, 7, and 8, my lord.
Yes.
Their names are
SP Chaudhary.
SP Chaudhary,
Ambora.
S. Bros.
Ambora.
and P. Ahmed.
SP Chaudhary.
Then item number 6, 1 P. A. Ahmed. And in 7, my lord,
S.V.
S. B.
Prasad.
my lord.
P. Ahmed, we know him, and obviously Mr. SP Chaudhary. The names are shown. If they're not there, we go ahead.
Yes, my lord.
First, we take which one?
Item number 5, my lord.
121.
Yes, my lord. My 120. In this batch of repetition, my lord, there are a number of repetitions which was allowed by the order dated 21/12/2021.
21, 12.
12/2021.
Judgment.
Judgment, my lord. That my lord will find at page 156.
It is a common judgment.
It was a common judgment, my lord.
Page?
Page 156. Starts from page 156. Judgment and order, my lord.
Okay. (156), yes.
My lord. This basically, my lord, pursuant to an advertisement dated 11/3/2018 for appointment of assistant teacher in lower primary.
11/3/2018 advertisement.
And an advertisement was issued. That advertisement, my lord, will find that
advertisement for
appointment of assistant teacher in LP and UP school.
LP and UP.
UP school. That my lord will find at page 94.
Yes.
Basically, it relates to age relaxation. So the relevant criteria for age, my lord, that will my lord will find page 95. Criteria number 3. A candidate, page 95.
95, yes.
A candidate must not be less than 18 years of age and not more than 38 years of age as on 1st January 2018. Relaxation of upper age limit will be considered for SC, ST, and person with disability for 5 years as per norms. So at the time of issuance of the advertisement, the upper age limit was 38 years for general category candidate, my lord.
Just a minute. Not less than 18, not more than
38.
38 of age as on
1st January 2018.
1/1/2018.
Yes.
SC/ST 5 years.
5 years, my lord.
And PWD 5 years.
As per norms, my lord. Thereafter, my lord,
yes,
there were some changes in the age criteria, my lord. And government issued OM and relaxation was given. Accordingly, my lord, an addendum was issued.
Well, you have to explain what kind of relaxation given.
My lord, my lord, may come page 25, my lord. That is the first relaxation given by the
25.
25.
Yes.
44 years, revised up to 44 years, my lord. In
the upper age,
my lord. In supersession of government office member so and so, the upper age limit for entry of grade 3, grade 4 jobs in the state government is hereby revised to 44 years with effect from 3/3/2018 till 31st of March 2019. For this specific period, it was revised up to 44 years.
Why for this specific period?
Because, my lord, during that period, my lord, there are no recruitment. So most of them have been crossed their upper age limit. That is why
Upper is extended.
extended. That is the reason, my lord, it was extended, my lord.
Extended to 44 years.
44 years.
For the period?
For the period 3/3/2018 till 31st of March 2019. For a period of 1 year, my lord.
Yes.
Here, my lord,
So in that year, somebody up till the age of 44
yes,
could have applied for.
would have applied for.
Okay.
There one more clause, my lord, there shall be no change in the procedure for recruitment or any relaxation of educational or other qualification or service condition such as year or age of retirement, etc. This relaxation shall be applicable only to those candidates who have attained the necessary educational or other qualification prior to crossing of their existing upper age limit of 38 years. That was the condition incorporated in that relaxation OM, my lord.
That means a person who had in the meantime attained the educational qualification
Yes.
will not be
No, my
eligible.
lord. Yes,
The other qualification have to be achieved before reaching 38 years.
38 years.
Only for the purpose of age,
Yes, my lord.
he will be accommodated.
Yes, my lord.
Provided he has
Had the qualification.
he
of
has met all the required qualification before the age of 38.
38 years.
Okay.
That OM was subsequently extended in case of OBC also, no? Page 26.
This was initially for whom?
This was initially for SC and ST.
SC.
General SC, ST, my lord. 3 years extended on 25th of April 2018, my lord.
Okay.
Hereafter, my lord, on this, on the basis of this OM, my lord, the addendum was issued. That addendum was issued, my lord, will find at page page 123.
1, 2, 3.
1, 2, 3. Serial number 3. The upper age limit is hereby revised up to 44 years in respect of general unreserved candidate, 47 in respect of OBC, MOBC, and 49 in respect of SC, ST, and persons with disability candidates as on so and so. So that was extended with the condition that they has to acquire the educational qualification before 38 years.
Okay.
So though this advertisement was issued in the year 2018, but due to some litigation regarding conducting of TAT, there was stay, my lord. Ultimately, pursuant to the order of this division bench of this honorable court, my lord, the recruitment process was again reinitiated, white notice dated 23rd January 2020. That, my lord, will find at page 132.
Page?
Page 132, my lord. first two paragraph, my lord, this is a narration of earlier advertisement. Then second paragraph, subsequently in compliance of the order of the Honorable Gauhati High Court dated so and so, passed in so and so, the candidates who have passed the teacher's eligibility test and have all other requisite qualification as per the DE Assam advertisement mentioned above are hereby requested to apply online against the so and so number of vacant posts, regular teacher, LP and UP through the official website so and so till midnight so and so. Here, my lord, the age criteria again revised. The minimum is applying 18 years and the upper age limit of 38 years for general, 41 years of OBC, 43 years of SC, ST, and persons with disability as on 1/1/2020.
Why again change?
Because subsequently there are other OM, my lord, issued by the personnel department, and on the basis of that OM, my lord, it was again changed to 2020 because that relaxation was initially given for only for 1 year, my lord.
This notice is in supersession of 11/3/18.
Yes, my lord.
The first one.
Yes, my lord.
Fresh recruitment notice.
Not fresh recruitment, my lord. This is a notice inviting application pursuant to that earlier advertisement, my lord. Not in supersession, but since that as relaxation during the time revised only for a period of 1 year, my lord. And during that period, my lord, that OM was
You can
applicable.
say further notice.
Further notice, my lord.
In continuation with 11/3.
11/3.
Yes, thereafter.
Thereafter, my lord, the petitioner, they approached this honorable court for extension of the last date of submission of application. That, my lord, will find at page 136. The relevant portion of that order, my lord, 140. They were unable to apply online because they have already crossed the upper age limit, my lord. So they approached this honorable court, and this honorable court passed this order, my lord, at page 140. Art so and so, the second paragraph, lord. The matter pertains to extension of time for submitting offline application pursuant to advertisement dated 11/3/2018 for appointment to the post of LP school teachers. This court, in number of cases filed earlier, had extended time with the consent of the state initially till 4:30 p.m. of 13/2/2020 and later again extended up to 6 p.m. 13/2/2020. This court of the view that further extension of time may not be appropriate and may create inconvenience to the administration. However, it is for the administration if the petitions apply to the authorities in their wisdom and discretion to accept the application or not. Accordingly, the petitioner may approach also offline application or with this observation that this petition was disposed of, my lord. Against this, my lord.
So what was the order ultimately?
Ultimately, liberty was given to file an offline application, and it was the discretion of the authority whether to accept or not, my lord.
This is WPC?
WPC, my lord.
Number of WPC, the one.
One, my lord. The 9/3/2020.
Where do you get 9
Page 136, my lord.
9/3/2020?
Thereafter, my lord, they sought review of this order, my lord.
Just a minute. Yes, but the petitioners were given liberty to file
Yes, my lord.
offline.
Offline, my lord. Thereafter, my lord, the petitioner filed a review petition seeking review of this order.
What kind of review?
Because the main relief that paid in that writ petition, that was not adjudicated upon. And my lord, we have not accepted their offline application. So they sought for review, my lord. In that review, my lord, that order will find at page 144. It's order dated review petition number 63 of 2020, page 141. And relevant portion 144, my lord. Page 145, paragraphs 6 onwards, my lord. Having heard learned counsel for the parties and also on perusal of the materials on record, this court is also of the view that the learned counsel for the petitioner.
Paragraph 6.
6. Having heard learned counsel for the parties and also on perusal of the materials on record, this court is also of the view that the learned counsel for the petitioner in WPC number so and so did not praise the said claims on that day, but merely sought for extension of time for submitting online application pursuant to the advertisement dated so and so for appointment to the post of LP school teachers, and accordingly court passed the said order. Accordingly, as far as order passed by this court on so and so, this court is of the view that there may not be any need to review the order dated 14/2/2020. However, since the review petitioner have submitted before this court today that the learned counsel for the petitioners did not perhaps bring to the notice of this court the main relief's claim, and since the main relief's claim were not adjudicated, the review petitioner may be given an opportunity to approach this court again to hesitate the same as similar matter are pending before this court. Learned counsel for the respondents have raised no objection to the submission. Accordingly, though this court is not passing any order reviewing the order dated so and so, it is made clear that since the main relief's claim in the writ petition were not adjudicated upon and no order was passed on merit, the review petitioner would be at liberty to approach this court again if cause of action will still survive for seeking grant of relief as claimed in WPC number so and so. In other words, the order passed by this court on so and so will not come in way of the review petitioner to file a fresh writ petition seeking above relief claim in the said writ petition. Thereafter, my lord, they have filed the present writ petition, my lord. And that prayer, my lord, will find at page 92. This is writ petition number 2771/2021, which was decided by the order impugned, my lord.
Page
78 is the writ petition, my lord, copy of the writ petition. We have annexed page 78, writ petition number 2771/2021. And page 92 is the prayer portion, my lord. In the prayer, my lord, in the premises aforesaid, it is therefore respectfully prayed.
Where is that page?
92, my lord.
90.
It is therefore respectfully prayed that your lordships may be pleased to admit this petition, call for the records, issue a rule calling upon the respondent to suppose to why a writ in the nature of mandamus or any other appropriate writ, order, or direction of like nature shall not be issued, quashing and setting aside the clause relating to fixing upper age limit of 38 years as prescribed in the notice dated 23/1/2020, and further be pleased to issue appropriate writ, order, direction allowing the petitioner to participate in the selection process, considering their upper age limit as per addendum dated so and so, and allow them to participate in the subsequent selection process, condoning their age. So, my lord, from
The OM was not given effect to. What was their grievance? If you read the relief
Yes,
portion, quashing the and setting aside the clause relating to fixing upper age limit of 38.
Yes, my lord.
Initially, as you have pointed out, it was 38.
38.
Then there were government
Yes, my
notification
lord.
raising the Upper age
up to
for
44.
various categories.
Yes,
44, 47, 49, whatever.
yes, madam.
Now that was for a particular year,
Yes,
1 year.
Yes, madam.
Now there were further notice in
Yes.
continuation after the office memorandum of 18/4/2018.
Yes, madam.
Now what was their grievance in this?
Because, madam, last further
Because
notice,
they had approached the court first time for extension of the date of submission.
yes, madam. That was
And for her copy for applying on
offline.
on offline mode.
Offline mode. And
And they were given that liberty to file offline.
offline.
Review they had failed.
Review failed, madam.
But review they are given
Given liberty to approach this honorable court again, madam. And now they have filed this writ petition claiming that their age has to be counted as per the addendum dated 29/10/2018. Because in subsequent notice, my lord, we have again fixed.
So what is wrong in that? Your continuation notification
Yes.
was issued only because of the addendum.
Yes, my lord. No. Addendum was issued, my lord, because there was a relaxation given by the government in the personal department.
Correct.
That is why addendum was issued.
Hmm.
Subsequently, my lord, due to interim order passed by this honorable court, thus this process could not be completed within the time, my lord.
Hmm.
Thereafter, this honorable court allowed to proceed with the selection
That
process.
you said there was a stay order, so there was a there was a gap. So thereafter, another notice was issued on 23/1/2020 in continuation with the initial notice of 11/3/18.
Yes, my lord.
So thereafter, they wanted to submit offline.
Offline. Basically, they wanted to apply with as per the date prescribed in the addendum, because as per the notice dated 23/1/2020, on that day they are not eligible, my lord, because they have crossed the upper age limit
Of 38.
38, my lord. That is their grievance, my lord. That was not adjudicated upon. They prayed for offline. That was allowed. We have not accepted. They filed review.
Now, what is your stand that this addendum would not be applicable? Why shouldn't they get the benefit of the addendum?
Because, my lord, in subsequent notice, we have fixed the age limit up to 38 years, my lord. Because that addendum was issued only because the OM issued by the personal department give relaxation for 1 year only. And that was expired, my lord. When we issued the subsequent notice, my lord, that relaxation was expired, my lord.
Let us see 132 again.
132, my lord. Yes, my lord. Third paragraph, my lord. The minimum age for applying is 18 years, and the upper age limit of 38 years for general, 41 years for OBC, and 43 years for SC, STP, STH.
So you have fallen back to the original age criteria.
Yes, my lord.
Which was in the original notified on 11/3/2018.
So they are not eligible as on 23rd January 2020.
But what was put to challenge in the petition?
They have put to challenge in this criteria, my lord. This criteria of 38 years.
What has been held by this court?
Because all petitions was clubbed together and the order impugn was passed, my lord.
No. What has been held by the court?
My lord, in that case, my lord, I would like to go through the order passed by this honorable court.
Yes.
Page 157, the paragraph 3, my lord.
Yes.
Paragraph 3. At the outset, the learned counsel for the parties have submitted in tandem that the principal issue has already been decided by the scored-wide judgment and order dated 9/11/2021 passed in bunch of writ petition, including so and so. That being the position, narration of facts of each case is considered unnecessary. Suffice to mention that the grievance of the petitioner are in connection of denying the benefit of appointment as assistant teacher of LPA UP in spite of being placed higher than the candidates who have offered such appointment. This paragraph is line important. The only discernible reason, as indicated above, is inability to acquire qualification of TET DLED before a particular date. This is, however, no dispute that the fact that all the petitioners are otherwise equipped with the qualification of TET DLED prior to the date when the recruitment process has begun. This is incorrect, my lord, because they have not having the qualification of TET and DLED when the recruitment was begun, my lord.
In that case, which date will you recon? 11/3 or 23/1?
That my lord will find, in fact, in their statement, repetition, they have stated that they have acquired the subsequent DLED and TET after 2019, my lord.
After 2019?
Yes, my lord.
So
because they have pursuing the DLED course for the year 2000 session 17 to 19. So obviously they have acquired it after 2019.
But if your further notification at 132, page 132.
Yes, madam.
23/1/2020, what does it say? Will it give them a chance to acquire the educational qualification till this date? Or will it mean that as on 11/3/2018, they are required to have the educational qualification?
That has not been mentioned in this notice. That has not been mentioned regarding acquiring of qualification, my lord.
132 has to be read again. 132 has to be
Yes,
read
ma'am.
again. It is
for
information that all concerned that the director so-and-so had published advertising the NB for recruitment so-and-so and so-and-so on 11/3/2018. We have seen this, okay? Provision number. Subsequently, in compliance with the order of the High Court in so-and-so, the candidates who have passed the TET and have all the other requisites as per the D, some advertisements mentioned above are hereby requested to apply online. Minimum age for applying is subsequently. What is the second paragraph, Mr. Khatuniya?
Subsequently, in compliance of the order of the Honorable Gauhati High Court, dated so-and-so, passed in WC on so-and-so, the candidates who have passed the teacher's eligibility test and have all other requisite qualifications as per the DE Assam advertisement mentioned above are hereby requested to apply online against the said number post vacant of regular in LP and EP school through the official website so-and-so. So, pursuant to the order of this Honorable Court, whereby we are allowed to go ahead with the recruitment process, madam, who have acquired the requisite qualification as mentioned in the advertisement of 11/3/2018.
Where do you get this?
Here, my lord. In compliance of the order of the Honorable High Court, dated 28/3/2019, passed in so-and-so, the candidates who have passed teachers' eligibility test and have all other requisite qualifications as per the D advertisement mentioned above. That
mentioned
advertisement
above means
11/3/2018. Secondly, my lord, in paragraph 5, there is one more finding, my lord. Paragraph 5 of the 158, page 158. It is an admitted case that it is an admitted case that none of the petitioners had acquired the TET and DLED qualification within the upper age prescribed for various category. However, it is also a fact that even before the advertisement dated 11/3/2018 was issued, all the petitioners were possessing TET DLED qualification. It appears that due to non-fulfillment of the aforesaid criteria TET DLED, the candidates of the petitioners were rejected. So this finding is also incorrect, my lord. They have not acquired the TET and DLED as on 11/3/2018, which is apparent from their pleadings in the writ petition, my lord.
It is admitted in some of the petitions. You said that before 11/3/2018, this petitioner did not have the
Yes, my lord.
TET.
Yes, my lord. That is their admitted position in.
Yes, yes, what do you say? It's a very objective kind of examination we can do. Did you possess TET, DLED or before 1/11/3/2018?
My lord.
You had?
My lord, petition after that. Now, my lord, when initially advertisement was issued, my lord.
No, if you have just show it to us, is that the only point, Mr. Khatunian?
Regarding my lord, authorized, because my lord, if my lord will find the affidavit of the at page 93, affidavit filed by the petitioner number 1, my lord.
In this review petition?
In the page 93, in the writ petition. The writ petition was filed in the year 2021. On that day, my lord, in fact, my lord will find the date at page 80 also. Date of all the petitions are given in the cost title, my lord.
Okay.
Page 80, my lord. This writ petition was filed in the year 2021. The age of petitioner number 1.
No, see, we have to concentrate on your grounds of review.
Yes, my lord.
You may have other grounds, but we may not be able to go into. We have to deal with grounds which forms grounds of review.
Yes.
Means error apparent on
Yes,
the face. 5, you're trying to make out a case of error apparent on the face.
Yes.
It's a wrong finding on the face of it.
Yes, ma'am.
Since none of the petitioners against whom the review have been filed, they had possessed TET or DLED on or before 11/3/2018. That is the factual clarification we get from the learned counsel for the petitioners, writ petitioners. And the other is the other a ground for review?
Yes, my lord. There is one more ground, my lord, because what we are trying to project, my lord, they have crossed the upper age limit of 38 years as on 23/1/2020, my lord, when the further notice was issued. On that day, they have crossed the upper age limit of 38 years. So, as per
where is the finding that they are within the age?
That, my lord, regarding that, my lord, there is no finding in the order impugn.
Then it can be a ground of appeal.
But
if you have not given a finding, how do you come before?
But thing is that on the particular date when the application was invited, they are not eligible, my lord. But by the order impugn, my lord, they are allowed to consider their case for.
So there has to be a finding of the court, which can be termed to an error apparent.
Regarding the
Okay, we are not precluding you from raising that. First, let us
yes,
have their response.
In the meantime, I'll try to find out if
Yes,
there is
yes,
any.
yes. This is a very easy thing. You just show us that.
Regarding this issue, my lord, in an admitted position that petitioners are eligible as on 1/11/2018.
Show us your TET or
Paragraph 8, there is specific government.
paragraph
8 of my.
writ petition. You are in item number, this item only. Item 5. We are taking item number 5, isn't it? This, Mr. Attorney, this is 5. 121 is 5.
5.
Where is the writ petition? It starts at page 75.
Yes, ma'am.
75, there were 9 petitioners, right? Where is the averment that you had?
Paragraph 8, ma'am. Page.
Meetings of.
Yes, please.
Petitioner Soya, reasoning in terms of age from the date of advertisement, that is given in 2018. And all got eligible when the maximum age limit was raised 44 years.
That is not a statement. And all got eligible when the maximum age was raised to 44 as per. That was not raised to 29.9. That was for a particular period.
No, my lord. Page 123 of the review, my lord, kindly. That my friend has not. 123, ma'am. This is issued by the Director of Limited Education. On earlier occasion, the submission of the petitioner was that this is not applicable in our case because that was regarding secondary education, my lord. Now, my lord, kindly have a look, page 123, lordship.
123.
Lordship. Serial number 3, my lord. May I read, ma'am?
Yes, please.
The upper age limit is hereby revised up to 44 years in respect of general unreserved category 47 OBC, MOBC candidate and 49 in respect of ST. The relaxation shall be applicable only those candidates who attain the necessary qualification or other qualification prior to crossing of existing age upper age limit of 38 years. There will be no provision for upper age confirmation. And this was subsequently, my lord, withdrawn, my.
But you have to have even this is not going to help you. The relaxation shall be applicable only to those candidates who have attained the necessary educational or other qualifications prior to crossing of the existing upper age of 38. What Mr. Khataniar is contending that it is only in respect of the age that the relaxation is granted, provided you have the qualification prior to attaining 38 years of age.
Now, my lord, in that-
Your pleadings is ambiguous. You said that in fact it can be held against you. All got eligible when the maximum age limit was raised to 44. That means in the period from 38 to 44.
Have petitioners have the requisite academic qualification and they are also debt qualified and obtained DLS from the recognized institution.
When?
At the time of advertisement dated 1/3/2018. 2018. Page, my lord, continuing of the paragraph, my lord, 8, lord.
Have the requisite and they also have TET qualification and other there. Advertisement.
The time of advertisement dated 1/3/2018. The petitioners are pursuing their DLS for the session 2017-19. Subsequently, they have completed their.
So if you are pursuing, how could you have attained?
Now, my lord, subsequently, the advertisement was challenged both Honorable Court, my lord, and the Honorable Division Bench of this Honorable Court allowed the candidates who could not complete their this Honorable Court directed to conduct fresh TET, my lord, because there was TET had not conducted for certain periods. So in my case, my lord, almost all of them, my lord, there may be one or two candidates, my lord.
But here you have made a statement, petitioners were pursuing the DL ad for the session 17-19.
My lord,
So before, as on 11/3/2018, you could not have had the qualification.
my lord, I was having TET, my lord.
Now what is it in the alternative?
The TET is, the DLED is, my lord, the diploma course which is required. my
Now
lord.
what is the requirement in the advertisement?
My lord,
I will find the advertisement page 95, my lord. Page 96.
What do you need to have?
Page 96, secondary equivalent with at least 50% marks and 2-year diploma in elementary
so
education.
my
That
lord,
is
one thing,
DLED.
my lord.
96? Serial number?
Minimum qualification.
Serial number.
A, my lord. A.
A.
A, my lord.
Secondary education, secondary Senior secondary,
secondary or its equivalent.
50% and 2-year diploma
Yes, my lord.
in elementary education. That is
That is DLED. my lord.
DLED. DLED is must.
Yes,
No,
my
my lord, after 2017 only state started DLED, man.
Hmm?
After 2017 only DLED was started, man.
Okay. So
So prior to that, DLED was not there.
if it says, how long is the course?
1 year.
1-year course.
No, my lord. It's
No,
2 years
sorry,
course.
man.
2-year course.
In service, 1 year. 2
Yeah,
years.
2 years. Now it is.
So how is it possible to have this qualification
No, my lord,
on
2018,
18?
man.
No, my lord, it's incorrect, my lord. We have started 2017.
That is the
It is
reason.
incorrect, my lord.
There was
DLED
notification, my lord, Union as well as state government, my lord, for in-service candidate for undergoing that, my lord.
No,
Initially,
Mr. Khatonia,
Yes, my lord.
if what Mr. Laskar is contending is correct, that this started in the year 17, it's a 2-year course. So how do you expect a candidate to have this qualification
No,
in
no, it is
2008?
incorrect, my lord. We have started for in-service candidate because it was a NCT
Requirement.
requirement.
Yes.
So we have started for in-service candidate in the year 2017, my lord. For other candidate, my lord, they can acquire, my lord, because it is available in the IGNOU and all other institutions. It was available.
And for in-service, it's 1 year.
1 year because
So even they could have.
yes, my lord. To meet the criteria, my lord, we have.
No, no, my lord, with due respect, my lord, in this case, my lord, initial, whoever obtained TET qualification, my lord, they are not having a DLED course, my lord, because there are no TET course available. And thereafter, my lord.
No, see, Mr. Laskar will go by the minimum qualification which has been prescribed in the.
That qualification was not there, my TET qualification. That is the reason why.
No, that was not the will. What will go by whatever has been prescribed. The advertisement is before us, page 96.
Oh, that is the reason, my lord, subsequently, the 1-year course was incorporated, my lord, for teacher having.
We are not going into those aspects. We are dealing with a review petition.
My lord.
He has made a categorical case that while this court in paragraph 5, isn't it? Or which
Yes.
paragraph?
Paragraph 3, then paragraph 5, my lord.
Paragraph 5 has come to a findings in paragraph 5 that you had the educational qualification on 11.3. That is incorrect. First, you have to confront this statement of facts, then you have to even perhaps I show that you have the qualification by the document.
In this case, my lord, then I got to produce the record.
Not records, where we don't even find the statement. The statement is not there. First, if you are able to satisfy the court on the statement, then you would again ask for the document, because this is something very important. Now the statement is even not there. And rather your statement is on the other, to the contrary, that 17 you have started.
Now, my lord, read April 32 of 2019. They have challenged, they are not even having TET qualification, my lord, that will be a point of time. They challenge writ petition and this one, read appeal, my lord, division bench of this court. My lord, by.
Mr. Laskar, will be confining our discussion deliberation on the review.
No, my lord, in that case, 32, read appeal 32 of 2019 is also required to be taken into consideration, my lord.
Where is it?
My lord.
Item number?
No, my lord, we have annex in this. That will, my lord, will find that page.
124.
That is with regard to the TET qualification, my lord.
My lord, even 318, those candidates are not having the TET qualification.
124. What is it? Now, Arup Kumar Medhi was taken into consideration, and then only the second notification was.
Yes, my lord.
This was taken into consideration.
Yes, my lord.
No, my lord, that.
The second, the further notification, which you have termed as further notification, 23/1/2020. That is only because of this Arup Kumar Medhi. This we are not required to consider afresh. It has already been taken care of.
Lordship put a question, my lord, whether I was having the qualification.
Yes, that is the question.
Now, my lord, in 32 of 2019, my lord, the writ petitioners, the writ appellants were not even having the TET qualification as per advertisement given date 28, 2018. And by virtue of this honorable court's order, my lord, TET conducted, my lord, a TET qualification. So, my lord, they were not even 318, they were not having TET qualification also, my.
Mr. Laskar, this should not be a relevant consideration for us when we are deciding the review petition. We would be deciding the review. See, you have passed a judgment. They have contended that while passing the judgment, there has been an error apparent on the face. And one of the errors is paragraph 5 findings, which they say is contrary to your pleadings in paragraph 8 at page 85. This appears to have substance.
Now, my lord, by virtue of this order, my the writ appeal order, my lord, there is a categorical observation.
Again, Mr. Laskar, you are going to writ appeal. Writ appeal has been taken into consideration in 23. We are not going to the writ appeal at this Arup Media order. That is not before us. We cannot even touch that order. 23/1/2020. Come to page 132.
132, needless to mention that the respondent state announcing holding of the.
132.
132. 132. Second paragraph, subsequently in compliance of the order of the Honorable High Court dated so and so, passed in so and so.
Now, this is regarding writ petition, ma'am, and I, my lord, showing the writ appeal.
28/3/19.
That's wrongly mentioned in the order was.
See the date of the order.
Date of the order is same, writ appeal order, my lord.
Writ appeal order.
They have mentioned. as
The writ petition number. We have seen that. It's a writ appeal order. So, Laskar, you may not have a case.
Now, Lord,
Unfortunately.
my lord, the petitioner seeking the similar treatment, considering the fact that, my lord, that.
The similar treatment if you have the educational qualification.
My lord, I was having TET.
Is that a requirement?
TET qualification is on.
Is that a requirement? What was the required qualification? Huh?
Both are required.
Both
are required.
Both.
And the petitioner of, my lord, of Arup Mehdi, my lord.
Yes.
They are not having TET qualification at that time.
We are not going into that.
Now, my lord, that is
Sorry.
vital, my lord, considering the fact that
Sorry.
they were given the opportunity to acquire their qualification, though we are having TET qualification, man. They were allowed to acquire their TET qualification in spite of that fact that they were not having the TET qualification at that particular point of time, man. And that is our pleaded case before in the proceeding, man. They were allowed to acquire the TET qualification, my lord. We are having TET qualification, my lord.
Please read again 132, second paragraph.
Subsequently, in compliance of order of the Honorable Gauhati High Court dated candidates who have passed and have all requisite qualifications.
Who have passed
TET.
And have all other requisite qualification as per the advertisement mentioned above means 11/3/2018.
My lord, Arup Mehdi, they were not having TET qualification on 11/3/2018, my lord. 11/3, when advertisement was issued, my lord, Arup Mehdi was not having TET qualification, my lord.
Is that the issue before us?
My lord, my contention before this honorable court was in the proceeding, my lord, that there are those candidates, those who are not having the TET qualification when advertisement was issued, my lord. And we are having the TET qualification at that point of.
What about the other qualification?
DLED, my lord, I have acquired, my lord, because till.
When have you acquired?
2017-19 batch, my lord. And till 2017, there was not TET DLED course, my lord.
It was, Mr. The Khatania has clarified.
No,
1 year was introduced only for in-house.
No, my lord. 2017, my lord. In that regard, my lord, I may introduce documentary evidence before your lordship.
Prior to that, you could have, a fresh candidate could have obtained the qualification.
Now, my lord, initially.
Now, from in-house, relaxation of 1 year also given.
No, in-house, my lord,
So if it's,
I know not to satisfy.
you will not have a case. Yes, Mr. Laskar. Same, similarly situated. Do you have a better case on facts?
It's the same way.
See, facts are the same. See, this statement of yours, pleadings of yours, that you were pursuing that course for 17-19, that will be against you. And that will be against you in the context of the findings of in paragraph 5 of the judgment. And Madam Kashyap, similar. Which is your repetition? Which item number? That's all. The pleadings are the same, Mr. Khatonier?
Yes, madam.
Same?
Same.
Identical?
Identical, my lord. In fact, this review petition, unfortunately, my lord, I'm not.
Your Banasri Thakur, your client? Where is the repetition page? 65.
Laptop to customer, stop copy. Stop copy. No, probably we don't need it. But it's one of the no, wait, but the podiums.
How many of you are there? 22.
No. Importantly, to bonus it. What will happen? Take it away. Yes, sir.
Oh, paragraph 17.
Yes, sir.
Paragraph 17, madam. And acquired the petitioners could acquire the qualification of DLED by completing the course as on 31/3/2019. See, Mr. Laskar and all the,
My lord.
see whether,
This,
no, see, the powers which we are exercising is review. The findings which we have come were on the basis of a wrong statement, wrong finding recorded in the assumption that you have already acquired. Now you may still have a case that
case,
based on Arup Medhi,
there is, my lord, one aspect.
but those will be matters of appeal, cannot be matters of.
The contention is that we don't have a qualification DLF
Yes.
before 2018 notification.
Yes, 11 is correct.
Yes, but we may have acquired the qualification during the period that the upper age limit was increased.
That is not their case. In all of the subsequent notification, they have said that qualification, otherwise you have to have on the initial date of advertisement.
Can we,
If that part you are entitled to challenge and you can successfully do so. But we had proceeded on a wrong presumption. We assumed that you had the qualification.
my lord, your lordship has cited a office memorandum issued by the personnel department. It is, it says there is a clarification and it's put at, made.
That was for a particular period.
That was,
No,
in that case, my
it
lord,
should be
I
clear.
can clarify it, my lord.
This relaxation shall be applicable only to this candidate. This, it says, during the pendency of the writ petitions, a very interesting and material development had taken place in the form of a corrigendum issued by the personnel department. It's paragraph 9. By the said corrigendum dated 20/2/2021, it has been clarified that so far as the department's office memorandum number so and so dated 2/9/2022 is concerned, the second sentence in paragraph 3, namely, this relaxation shall be applicable only to those candidates who have attained the necessary educational or other qualifications prior to crossing of their existing upper age limit of 40 years, shall be deleted from the said office memorandum. So if this is deleted, then we are not required to have a qualification before 38. We can have a period after.
Which page are you reading?
It is page 127 in item number 70.
No, in Laskar's case, is it there?
162, paragraph 14, 114.
Page 162.
Because this is clear that we are not required to have qualification.
Just a minute, just a minute.
In fact, that OM is annexed with this review petition, my lord. That will, my lord will find at page 55.
162 is not there. Oh, in your case. Okay. This is what? This is Manasri is madam's case. Yours is different. 164.
163.
Yes.
Not the case in the respondent that the petitioner does not possess qualification of state DLA. And the objection is only with regard to the date where qualification of state DLA was required. As per advertisement, the aforesaid qualification was required to be procured within a particular year. However, due to non-holding of the examination, such degree was not able to be obtained within the prescribed age limit. However, there is no dispute that such qualifications has been obtained starting of the recruitment process. Accordingly, this court finds both the document on behalf of the petitioner that by virtue of that DLA qualification acquired later, the same relates back, and therefore the condition requiring more qualification should not be attained within a
Should be
attained within a particular age agreement made by the petitioner.
Mr. Khatunia,
Yes, madam.
we have applied our mind and come to a finding.
Yes.
You may be aggrieved. If you are aggrieved, you file an appeal.
This, actually, this content.
You may be correct in contending that their statement in paragraph 5 for Laskar's case may not be correct. But the issue which had ultimately arisen, that we have addressed.
Yes. These contentions were raised.
We have addressed.
Yes.
We may be wrong in our addressing. For that, you have recourse in law.
This is one reason. Second limb of argument, my lord, regarding the crossing of upper age limit of 38 years at the time of initiation of recruitment process in the year 2020, my lord, subsequent notice. They all have crossed the upper age limit of 38 years, my lord. Though that aspect was not considered because regarding attainment of qualification was dealt with by this honorable court, my lord. Therefore, that aspect was not considered, my lord.
But discussion is paragraph 14.
Yes, my lord. That how
when this discussion is there, your first ground will not be able to contain contend the first ground. You cannot urge the first ground.
But
We have discussed.
discussion is there, my lord. In fact, paragraph 17 also, my lord. That is regarding acquiring qualification within a particular age limit. That discussion is also paragraph 17 is there, my lord. That discussion is there, but
You challenge in an appeal. Will not be fair. Because had there no discussion, had we proceeded on the basis of their statement that they had the qualification which is wrong. But we had said that why qualification could not be obtained because the examination was not held. Whether that conclusion of ours is can be successfully challenged, that's a different matter. You can test it.
it was correct that TET was not held. Subsequently,
You can test it. You can test it. You can test it. But we'll have to rise early today. We're giving some more time to you.
Yes,
but we have 14. Mr. Laskar, you should have pointed out 14. We have not pointed out 14. 14 will clinch the issue. Khatone is absolutely right. Findings in paragraph 5 is incorrect, may not be correct. But that incorrectness we have taken addressed in 14. So 14 discussions will overcome. Friday no. Kali to no. Kali to say division means say. But we have almost heard at least the review petitions. So far as contempts are concerned, Mr. Mahant will be there. We'll hear him.
Petition may be separated and.
No, let it be together. We'll hear it. Almost we have heard it separately. Today we have already made the notings. Just to give Mr. Khatania a chance. Otherwise, may not be a case.
As regards my
But if you pray for, we can grant you liberty to file an appeal. In the meantime, but may not be proper.
That, my lord, on next date, my lord, I'll.
Wednesday?
My lord, before 29, my lord, I will not be able from 29 to 4th, my lord. Can it be before 29th or?
We'll try to have it before 29th. 29th. 29th is next Wednesday.
It was.
Atha is a good matter fixed. When are you coming back? 4th?
On 4th, I'm coming back. Then on 5th, my lord.
We can have it on 6th.
Yes, my lord.
6th, is it okay? 6th. At the outset, 3 K.K. Mohantalan, Senior Counsel, appearing for the petitioners in the contempt cases which have been tagged together, has submitted that so far as his clients are concerned, no application for review has been filed, and therefore those matters be heard separately. Full stop. Para. So far as the review petitions are concerned, this court, this court has heard, there has been substantial hearing. Full stop. List for further consideration on 6/8/2026. Full stop. Para. It is, however, observed that the contempt petitions would be considered separately. Let this be a common order as of now. Later on, we'll segregate it. On that date, the contempt will also be listed, but we'll give a date or whatever. But review, we are going to dispose of on the next date.
At least those contempt may be listed separately.
Yes, no, let it come on 6th. Let the reviews be disposed of. The content will remain. We'll have a date or for if not possible on that date. Okay. Okay.
Yes, madam.